Well, good morning from our studios here at Adesawe in Accra. Welcome to the Key Points here on TV3, live on 3FM 92.7, also on TV3 Ghana on Facebook and DSTV channel 279, but all across the world on 3news.com. Of radio stations across the country. The most topical issues with the most passionate people who have committed themselves to advancing this country in the best possible way. This is Key Point. My name is Alfred Okanse. Welcome. This week, there's a 5-member panel of the Supreme Court chaired by the Chief Justice has granted a stay of execution of the ruling of the Speaker of Parliament, Right Honorable Alban Sumana Kingsford Bagbin, to declare the seats of 4 members of Parliament vacant over the switch of allegiance or the declaration to go or to contest as independent candidates in the upcoming December 7 elections. Following, there's this ex parte application by the Majority Leader, Alexander Afenyo-Markin. Alban Bagbin officially declared those 4 seats vacant a couple of days ago. They are Memphis Central, Fomena, Agona West, Sohum members of Parliament. They had their seats declared vacant. That effectively turned the leadership of Parliament and switched it. And the implications, we would look at it as well. Now, this decision effectively halts the implementation of the Speaker's ruling pending further legal review. In fact, that case yesterday that was heard, that ex parte motion, meaning that the Speaker of Parliament was not notified, went at the blind side of the Speaker in Parliament, head by a panel of Supreme Court justices that was actually presided over by Chief Justice Gertrude Tokonum. We'll tell you the judges who sat on this matter yesterday, all 5 of them, and their reasoning and reason why they put out this particular decision. In fact, in addition to granting the application, the court directed the Speaker and the Attorney General to file their statement of case on October 15. This case filed by Afenyo-Markin within 7 days. We have a thorough discussion and conversation on this matter this morning here on Key Point, and a number of reactions coming through as a result of this. Does this set Parliament on a collision course with the courts? Are we faced with a constitutional crisis, as some have feared? If that precedence set by Professor Reverend Aaron Michael Quay's ruling in the Fomena case was wrong and unlawful, as we have been told now, did we have to wait for it to fester on until this moment when some have indicated it flips against the NPP? It's a conversation that we will have this morning. And as always, I would be joined by a cocktail of lawyers who would help us understand where we are and what is ahead of us on the path that we are going. The Electoral Commission this week also, sought to disqualify the NDC parliamentary candidate for their Memphis Central constituency, Joanna Kojo, with a letter dated the 10th of October, but was made public at least on the 15th of October. The NDC addressed a press conference a couple of days ago indicating what they suspect could be the real intent of what is happening. But there's a lot going on in that particular constituency. We'll have a conversation on this morning here on Key Point. As always, you are an integral part of the conversation. There's so many ways you can be part of this. You have a voice and you have a say in what we say on Key Point. My name is Alfred Okanse. On behalf of the rest of the team, welcome. We'll be back shortly after this quick break. My guests will join me. The conversation starts right now. Stay with us.
Over 5 million children have benefited from free SHS. Protect free SHS. Vote Dr. Baumia, #1 on the ballot.
Welcome to Rehoboth Havens, a tranquil oasis in the serene surroundings of Aye Mensa.
Night, 100 leading companies, 100 coveted business awards. This is the Ghana Club 100, powered by GIPC. It's time to honor Ghanaian companies that have stood the test of time, made an impact, and are blazing the trail in their respective industries. Join us for the 21st edition of the Ghana Club 100 Awards on Friday, October 25th, 2024 at 6 p.m. at the Palms at La Palm Royal Beach Hotel. Purchase your tickets now via the USSD short code *365*2100#. Alternatively, you can call 0243-534-559 or 0247-600-860 to RSVP. This event is under the auspices of the Office of the President, Ranking Partner, KPMG, Ticket Partner, Koba, Diamond Sponsors, Platinum Sponsors, Gold Sponsors, Supporting Sponsors, Beverage Sponsors, Media Partner, TV3, Ghana Club 100, celebrating Ghana's business leaders.
Luckiest *712#.
Luck is everywhere.
8K. Hey, you get an 8K. Get a packing so you have one line. Hey, wait.
You go put it on his tab. This is my man. Good luck.
Hey, yo, we'll be ready.
We are *712#.
It's put your phone.
I'm on dialing the magic numbers. *712#. Now welcome to the luckiest. And now with me at home ticket. You can buy for yourself or your loved one.
Mommy, tell mommy who's here.
You're buying for me, right?
Or who else?
Oh.
Let me choose buy tickets for others.
Love you, boo boo.
Maybe straight to option 4.
Now we you need to buy tickets worth 50 Ghana to qualify. Yes, you can buy random or preferred tickets.
I'm choosing random ticket.
Listen, if you buy the random ticket, the system chooses a random number for you. But if you buy the preferred, you get to input your own preferred 5 digits. 5.
Baby, give me your 5 numbers.
And how much are we buying?
Babe, look at the body and buy you.
With your body,
Hey,
there, tread cautiously. Now follow the prompts and confirm. Now the luckiest.
The luckiest is regulated by the NLA on the Caritas platform, not for persons below 18 years. T&Cs apply.
Fellow countrymen and women, the desperate NPP, realizing that they are losing the 2024 elections, has once again resorted to lies to smear the nation builder, His Excellency John Dramani Mahama. The NPP's claim that Mahama was against free SHS and will cancel it when elected is nothing but a barefaced lie calculated to deceive you. John Mahama started the implementation of the progressively free SHS program in 2015 with day students and had a clear plan to expand the program to cover borders, hence cannot be said to be against free SHS. What he has been against is the poor implementation of the program. Contrary to the lies of the NPP, the next NDC Mahama government will improve the implementation of the free SHS program to make it better. We We will do this by scrapping the double-track system, provide a dedicated source of funding for the program, include private SHS, improve the feeding of our children, and enhance the quality of learning outcomes. Listen to the truth from the horse's own mouth.
Free senior high school education has come to stay. If anybody tells you that I, John Dramani Mahama, son of E.A. Mahama, will abolish free SHS when I come, tell the person he's a bloody liar. What I'm against is the poor implementation of the free SHS, which is creating great inconvenience for the parents, for the students, and for the teachers. And one of the things we'll do when we come back into office, and I know inshallah we're coming back into office, is to complete the 200 community day schools that we began, so that we can bring a quick end to the double-track system.
Beware of the NPP's lies. Vote for change. Vote for John Mahama and the ND
Radio.
Election Command Center. Facts, analysis, results.
Our edition. Get ready to witness the birth of musical stars. Join us as we unveil 16 extraordinary talents who are ready to compete for the ultimate prize and a chance to shine on the global stage. Who makes it into the main competition? Catch us live this Sunday, 20th October at 8 p.m. Remember, no studio audience. Mentor, the world awaits you. Mentor 13 is powered by Shaltox Lozenges.
Sponsored by Darling Lemon Drink, Darling XYZ Wine, Blue Jeans Energy Drink, and Upper Foods.
Welcome back to Key Point here on TV3. We're live on 3FM 92.7, also on TV3 Ghana on Facebook, DSFA channel 279, comments and opinions. My name is Alfred Okanse. Now, on the 12th of October, just about a week ago, the Tamale South Member of Parliament, a former leader of the NDC group in Parliament, Honorable Haruna Idrisu, gave a clear indication of what he intended to do when Parliament resumed, in testing the law and petitioning the Speaker to declare some 4 seats vacant. And these are the timelines as we have monitored and on the happenings so far. On that particular day, Haruna Idrisu was very clear the path that he was going to take when Parliament resumes. I want us to hear exactly what he said on that fateful day, the 12th of October, and all the other matters that followed. Take a look.
The Parliament of Ghana will reconvene. And when it reconvenes, I am very certain that Parliament and Ghana will go through a major constitutional test. And that constitutional test is that the ADC minority must become the majority for Wednesday next week. And I assume, and this must happen if there is constitutional and legal propriety in Ghana. Because any nuanced interpretation of Article 97 provides that if a member of Parliament on a political party ticket like MPP defects and fails to be independent, that MP ceases to be member of Parliament. And if an independent member of Parliament, by virtue of the provision of Article 97, subclause G, an independent joins a political party, that independent loses constitutional recognition and does not belong to Parliament. And even if an NDC candidate, MP, defects to become an independent, he ceases to be a member of Parliament. Therefore, we will invoke the Speaker's proper and true interpretation of Article 97.
And that's exactly what he did when Parliament reconvened on Tuesday. In invoking the Speaker's jurisdiction on this particular issue. And on that fateful day, here is what Dr. Kesel Atuforsin, the minority leader at the time, said in invoking the jurisdiction of the Speaker on the matter of these 4 MPs and their status and why Article 97(1)(hg) should kick in. Take a look.
In your ruling, my understanding was to the effect that your duty is not to interpret the Constitution. My understanding was to the effect that your duty is not to interpret the Constitution. But, Mr. Speaker, it is important for me to emphasize one more time that when the statement was made by my respected colleague, Dr. Kesel Atuforsin, I did draw the attention of the House, including your good self, to the effect that the matter being a very grave matter, I have taken it upon myself to seek the court's interpretation of the matter. Mr. Speaker, indeed, yesterday, Parliament was duly served. Mr. Speaker, the facts you put out are not true. Mr. Speaker, these are credibility issues, so I will respond for the record. Mr. Speaker, somebody has told you something. Mr. Speaker, you reserve the right to be there to make your point. Let me concede that this is a serious constitutional matter. Let me concede that this is a serious constitutional matter which has different views being expressed. I am a practitioner of the law and a student of the law. Having come across this controversy and for the sake of posterity, I have initiated, Mr. Speaker, an action at the Supreme Court. Would you remain quiet for me to argue? I listened to him in silence. I listened to him in silence. Would you remain quiet? That is democracy. You must remain silent and listen to me. You would have to be quiet and listen to me, and you will listen to me, and you will listen to me. You will listen to me. Yeah, you will listen to me. This is a legal argument. This is a legal argument. You have to listen. This is a legal argument. You must listen. Mr. Speaker, I have invoked the jurisdiction of the Supreme Court to aid us. And this is in accordance with your own ruling, that these are matters that we need the court to come in. Mr. Speaker, this process has been duly filed. I have the writ with me. Not only the writ, it's not a naked writ, it's not a lame writ, Mr. Speaker. I also have accompanying the writ a motion on notice for interlocutory injunction, which is also attached to it. The process, Mr. Speaker, has been duly served on Parliament, as I'm made to believe. Mr. Speaker, I am of the view that this is...
Honourable members, it is important to point out that the Speaker is called upon by the standing orders of Parliament, particularly Order 18, to inform the House of the occurrence of a vacancy of the seat of a member under Clause 1B to E, G, and H of Article 97 of the Constitution. Accordingly, I proceed to inform the House that by the notification of the polls, the following members of Parliament have by their actions vacated their seats in Parliament. The members are Honorable Peter Yao Kwache Aka, NDC MP for Amenfi Central in the Western region, now referred to as an independent parliamentary candidate for the same constituency. 2, Honorable Andrew Amwako Asiama, independent member for Fomna constituency in Ashanti region, now referred to as MPP parliamentary candidate for the constituency. 3, Honorable Kojo Asante, MPP MP for Suhum in the Eastern region, now referred to as independent candidate for the same constituency. And finally, Honorable Cynthia Mamile Morrison, MPP MP for Agona West constituency in the Central region, now referred to as independent candidate for the same constituency. These MPs cannot be allowed by law and my good self to continue to pretend to be representing people that they don't believe in and they don't have any loyalty for in this house any longer. The house is accordingly so informed. Honorable members, I thank you for your patience and attention.
That was the ruling of the Speaker as delivered. He made reference to a number of instances, the reason why he came to that reasoned judgment. If you recall, he had to take 48 hours to come to that reasoned judgment or the ruling that he read. Now, just some hours after that particular decision, yesterday, we got to know of an ex parte motion that Alexander Fenyomakin sent to the Supreme Court, which I would show you the specific reliefs that he sought at the Supreme Court as we go on. But effectively, what the Supreme Court did was to suspend the execution of the Speaker's ruling until the determination of the case before it. Now, there are fundamental questions of law that have been raised about this particular happening or this incident that occurred yesterday at the Supreme Court. And that's the conversation that we're going to have this morning. How far this case has traveled to this point. What are we confronted with as a people? Is it a constitutional crisis, as some lawyers have made us to understand? That's a fundamental but most important question this morning that we will be answering. Joining me in the studio right now is a professor of political science at the University of Ghana. He is a governance expert, and he has contributed to the democracy of this country in many ways. Professor Ransford Jampo, good morning. Welcome.
Morning. Thanks for having me. You know, we face an existential threat, irresponsible mining, and we set out to fight it, coming together to form organized labor to fight it. Now, some people try to compromise some two people leading this group.
Two people.
And some of us took exception to that backward practice. And what are they doing? Trying to resort to some very useless tactics aimed at attacking us, referring to their very bogus attempt at silencing some of us, which never worked. When they realized that that route was not going to work, then they said, oh, you are dancing an Onapo song. If I am dancing Onapo song, yensa. Common campaign hit song. Common danceable campaign hit song. You've not been able to compose. And if somebody has composed a music and somebody is dancing, that automatically makes him a member of the political party that used that campaign song. Does this thing make sense? When they realized that that one was also not working, then they went to very distinguished people who are supposed to have been educated, people who are supposed to be learned people, They use them to be sort of intimidating or talking to some of us behind the scenes. Oh, why are you doing this? Why are you not stopping this? And we ask ourselves, what are we seeking to achieve? We are fighting an existential threat. Illegal, irresponsible mining that would eliminate or will kill all of us. Then you have very distinguished people doing partisan politics and then trying to talk you out of it. And I ask myself, why? When that didn't work, then they tried to get to some of our people, UTAG members. They tried to get to some of them and manipulating them, and they are trying to use them to break our front. I mean, I don't want to talk about that particular issue so much because some of them are, our colleagues, and I don't want to contribute to the agenda of wanting to break our front. But to those deputy ministers, to those top party functionaries who were behind the effort to break our front, I'm telling you, I was on the phone when you were talking to them. I was on the phone. I was listening to you. You didn't know.
You were listening.
And so I'm telling you, you see, you can do all manner of things to divide and to break the front of some labor unions, but not UTAG. We are still on strike. You can go to hell. We are still on strike. But this government would go down in history as the most undemocratic government in the history of Ghana's Fourth Republic, because they are silencing, they are weakening the legislature, they are weakening the judiciary, they have silenced civil society, they have silenced the voices of eminent people, and they are silencing or dividing even the front of labor. Dear Ghanaian workers, I'm telling you, in the negotiation of base pay, rethink the caliber of people you send to go negotiate for your interest. Because some of the people, if you allow them to continue to lead you, they would remain rich and you remain poor. Thank you.
Well, thank you very much, Professor Ransford Jampo, for this. Your initial comments rather gives us an idea of this conversation of the Galamsey. We will have it. Well, thank you.
It doesn't make sense to me. What is this?
Thank you. Thank you very much.
Haven't you had governments before? We've had Jerry Rawlings, even Rawlings, who himself claimed that he was not a fan of multi-party democracy. Jerry Rawlings, he openly said he didn't believe in multi-party democracy, but he knew how to tolerate the existence of the dissenting views. Akufo-Addo, what is wrong? I mean, we believed in you. I drove from here to my hometown to go and vote for you. You can't tolerate dissent, and you resort to breaking the front of labor unions. Just for what? So under you, nobody should talk? What sort of government is this?
Professor Jampo, thank you for joining us. Martin Pebu is private legal practitioner. He is a leader of one of 3 individual bondholder groups, and then also one that has contributed to the legal jurisprudence of this country in many, many, many ways. He's been a lecturer as well of law in this country. Lawyer Martin Pebu, good morning. Welcome.
Morning, Mr. Kansi. Morning. Good to be here. Good to be here. I understand we are leading the charts, right? So this is the most watched and listened socio-political talk show on Saturday mornings, right?
Indeed.
So keep the good work, right? But as usual, let me start with greeting Gamanche, Kentucky Teku Churu II. The front, this leader for the quest for justice against the cash stashed by Cecilia Dapa under her bed. So much money. Gamanche is asking the authorities, how can one woman have so much money under her bed? Now it's over a year and we are still dancing around, right? With so much rigmarole. Gamanche is asking for justice on that Cecilia Dapa cash. So much cash. So much cash. More cash than we even needed to do our stadium so that we don't go begging Togo. You see, eventually we were saved by the last minute interventions. But it remains a shame, eh? Secondly, let me greet Osi Adeyo, Dr. Ajman Bedu II, Domahini, Yes, more fire, more fire. We need more chiefs. Yes, and God so Nana Kwesi Bosompra, right? Yes, he's the one who said, look, he calls upon the EC to do the forensic audit, right?
Yes.
And that was, I mean, quite exhilarating, quite exciting to see a chief step up because not many people were talking. And Nana Kwesi Bosompra did that. I dug my heart out to him. And finally, Yas Antwa Sofia Kufu. Good morning.
Morning to
More
you.
fire.
Thank you, Martin Pebo, for joining us. Palgrave Boache Dankwa, doctor, is the government spokesperson on governance and security. And this matter, or the two issues we're talking about this morning, borders on governance and security. He's joining us in the studio. Dr. Palgrave Boache Dankwa, good morning.
Good morning, Alfred, and good
So can say you didn't add a part of the family and friends government. That's the president's relation. Family and friends.
Okay.
They are your relations, are they not?
You see,
yes.
Okay. Dr. Palgrave Boache Dankwa.
Alfred, good morning to you.
Good morning.
I am surprised at the level of cabal that is coming from Prof.
No.
Coming from. I'm surprised. I'm surprised at the cabal that is coming from. Of course, I can never deny that I come from for pennies too. I can never deny that. But Alfred, let me greet the good people of this country.
Right.
Join the overwhelming parents who are mourning the lives of Mami Jumo Boateng and Justin Adbenu, the two young ladies that were involved in the accident at East Legon last week.
I think one of them is being buried today?
Yes, one of them is being buried today because that was the only one that they were able to get some remains of. The other just went together with the fire. But just to join the community, yesterday we had a vigil at the accident scene. Very, very traumatic event and very, very sad. And so I send my deepest condolences again to the family of the deceased, to the entire East Legon community, to the entire school community, Cornerstone International School, and really to state that the police should hasten the investigations so that we can be able to put this matter to rest. But it's very, very troubling. So our deepest condolences to all of them. And I hope that we have one of the best shows this morning that borders on the democracy of this country.
No, we are here. We will have a best with some of us. We came here very fired today.
We are
lucky last week I was not here.
We don't.
No. Okay. Yes, Dr. Palgrave Boache Dankwa, thank you.
Yeah, may I concur?
No, our condolences.
I was to the home of Mami Jumo.
Yeah.
Yes, I went there too. Yeah. Yes.
I thank you, and we all here do so as well. For on behalf of the Group CEO and management of Media General, also tag along in that same manner. Condolences to the families of these two. The Honorable Mahama Ayariga is the Member of Parliament for the Boko Central constituency. Is also a private legal practitioner joining us in the studio this morning. The Honorable Mahama Ayariga, good morning. Welcome to Key Point.
Good morning.
And
you won't say anything. That's all.
No.
You only respond.
I mean, yes, because he has a lot to talk about. So
I thought we will be given the opportunity to say things.
Yes, indeed.
You don't want to hijack.
Indeed. Let me also acknowledge the presence on Zoom. The Honorable Vincent Ekowasefwa is the Member of Parliament for the Old Tafo constituency. He is also a private legal practitioner. Vincent Ekowasefwa, good morning. Welcome to Key Point.
Good morning, Alfred. How are you?
I'm well. Thank you for asking. Let's first start off with exactly what was the basis of the ruling and the decision by the 5-member panel of the Supreme Court on this ex parte motion yesterday. Let's see that. First of all, these were the major issues and consideration. In fact, there were questions that were asked of the applicants, and the specific answers that they gave formed the ruling of the 5-member panel yesterday. One, these were the orders that the execution of the ruling of the Right Honourable Speaker of Parliament, Alban Suman Akinfo-Bagbin, dated 17th October 2024, delivered on the floor of Parliament, declaring vacant the seats of the following members of Parliament, is hereby stayed pending the final determination of this suit. Essentially, this is more of an ex parte motion that is unlimited, and that from some lawyers as well is quite odd. We would have a conversation on that. Two, in view of the gravity of the issues, since the Parliament of Ghana is hereby directed to recognize and allow the 4 affected members of Parliament herein named to duly represent their constituents and conduct the full scope of the duties of their offices as members of Parliament, pending the determination of this suit. They also ruled, in view of the gravity of the issues raised in this instant suit and the urgency of this matter, this court hereby directs that the Speaker of Parliament and the Attorney General are to file their statement of case within 7 days. Within 7 days. And the parties are further ordered to file their joint memorandum of issues within 7 days of filing of their statement of case for the due hearing of this particular suit. And this is the Afenyo Markin versus the Speaker of Parliament and the Attorney General. These were the orders of the 5-member panel of the Supreme Court yesterday. And it's an ex parte motion. So essentially, it was at the blind side of the Speaker and Parliament. Under the circumstance, how strange is this? Or in this instance, even though this is actually lawful, but looking at all the antecedents of it, how does it raise any questions for you?
Oh, 1,001 questions, right?
This particular ex parte.
Yes.
The route that was taken.
Yes, yes.
What?
So as you rightly stated, right? And look, even before then, I tell you, on some lawyers' pages and yesterday night, and other lawyers send me private messages, they say, hey, with this Supreme Court decision, where are we headed for? Some are like, hey, this country is going to go up in flames. So, you know, this decision is causing a lot of havoc. Look, the thing is that, yes, as you rightly stated, under the rules of court, you can go ex parte. When we say ex parte, that's going on the blind side of the other parties. So let me use the now common example. So let's say Evans sues Apedo, right? Then, but Evans thinks that the matter he's taking to court is so urgent that if they try to find Apedo to serve him, they will lose so much time that by the time they find Apedo, he would have caused much harm. So let's use the typical example. Let's say Apedo has gone into Evans' land and is building. So he's saying that, hey, if it takes even 3 days, the way he's building day and night at breakneck speed, by the time we get him, maybe he would have roofed it. So because of that, Evans can go ex parte before the court, so that if the court assesses all the evidence and thinks, yes, this is a good case, then the court will grant him an ex parte injunction or order, depending on what he wants. It's not only an ex parte injunction. It can also be the stay of execution that the Supreme Court granted yesterday. So the key thing we need to analyze is the urgency of the matter. How urgent is it? And when we say urgent, so what is being destroyed? What harm is being caused in the interim?
He's going to die.
Yes. So when you bring that to the instant case, as far as I'm aware, Honorable, you may correct me, I understand Parliament is resuming on the 22nd.
Tuesday, yes.
Tuesday. So it means that yesterday, today, tomorrow, Monday, no business in Parliament, right?
Yes.
So where is the urgency? I don't see it. Where is the urgency? So that is what we need to analyze. So, and when you read, you see, when you rush, that's the thing. You'll not be able to articulate your views, the reasoning. I read the proceedings and the rule. I'm like, I didn't see the urgent case being made out well. Oh, they will cause this and this and that. Just general, vague statements. So that is it. When you rush justice, that's what you get. That you will not be able to articulate well. I read it. I didn't see the case. To be honest, I go to court. So, I mean, that's where I make a living. So, when I'm saying this, I've thought about it carefully. Because we can't continue. We can't continue to be very timid. No. If you continue, you see, you strengthen the arm of the oppressor if you continue to be timid. I read it. I'm like, what is this? That's what I'm saying. Look, I'm here. I stand to be corrected. Maybe I don't understand it. So, I'm saying that under the right circumstances, the court can grant. Well, you want to read what you say.
So yes. I have a copy of this particular proceedings, a certified true copy of this orders and the decision by the Supreme Court, 5 justices yesterday. Justice Gertrude Tokono presided over this. Sowusu, Siedu, Gau, and Dakwa Sari, all justices of the Supreme Court. And if you look at the third page and the reasons why they give this ex parte motion even a hearing in the first place, and you question the urgency of it.
I don't see
so we refer to paragraph 8 and the enumeration of 6 grounds. Ex parte because of the likely mischief being a halt to the business of Parliament, especially committees chaired by the current majority members. B, likelihood of the current minority members doing everything in their power to halt business of government in these dying minutes of the period to 2024 elections. C, a delay of government appropriation which could require the approval of Parliament. D, the ruling amounts to a denial of the constitutional right of these 4 constituencies to be lawfully represented in Parliament. E, Exhibit B, the ruling on page 3, in doing so, clearly the Speaker of Parliament was usurping the original and exclusive jurisdiction of this honorable court, and he himself recognized it. These were the...
Good. So, yes. So, you see, now, the thing is that, as I stated, you said the mischief being a halt to the business of Parliament, especially committees chaired by the current majority members, right?
Yes.
So that's why I said the business is going to start on what? Tuesday. So what I expected the Supreme Court to do was that the Supreme Court would have said, no, we are not granting this. Go and serve the Speaker. So you say, look, we give up to make further attempts to serve on Saturday. If the Speaker is evading service, that is dodging them, then Sunday you may go ahead and publish it in the mass media, electronic and other print, social media. So others, or even you could even say, no, go and attempt. We'll sit Saturday evening, 8 p.m. And there's table number 4 here. The Supreme Court said, listen, the law is that the court will sit any day and time. If you read table number 4, verse Attorney General number 4, right? 2017-2020, Supreme Court of Ghana law report. That's the 48-hour decision. So, there was an earlier decision, Bernard Mona, decision, okay? There's Attorney General, where the Supreme Court had said, yes, they couldn't sit on a public holiday, blah, 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 because of the Public Holidays Act, right? But in table number 4, they struck it down and said, look, the courts, the executive cannot dictate to the courts when they will sit. So any time and day. All right, I'm sure that's not the major point. I mean, if you want to read it, you can always get it, right? So with that, I expected that the orders would not have been made there and then. No, you would have said, listen, it's Thursday, it's Friday. We are giving you the rest of this Friday afternoon up to the close, let's say by 8 p.m. on Saturday to find Speaker. If Speaker is evading service, his residence, etc. If he's evading service, come Saturday evening, the court will sit and now make orders for publication in the mass media. Or if the court didn't want to sit on Saturday evening, they will just say, okay, look, we'll make the further orders. If you don't succeed Saturday after 8 p.m., the second step is that serve the Speaker through the mass media, etc. Then, so Speaker has up to Sunday to respond. Then on Monday, the court will sit. So why this indecent rush? I mean, I find it, I'm like, Jesus Christ, are we sure? Yeah, you find very senior lawyers who say, hey, where is the Supreme Court taking us to? So you see, with the way the Supreme Court is gone about this, they are giving people the opportunity to say things that we've always shied away from saying, that it is a political organization. Yes, we all know. When there were vacancies in the Supreme Court, did you see them, Akufo-Addo seeking to appoint people who are affiliated to NDC or people who have sympathies for NDC? No, they will choose people that they think are sympathetic to their cause. You see, the moment you do this, the things that we usually would shy away from doing, we would say that it's a political entity. It's not by merit per se. It's more about the affiliation. After all, you don't write an exam to go into the Supreme Court. After you pass your bar exams, you start practicing 15 years at the bar, you qualify. So every lawyer, of course, provided you don't have issues of moral turpitude, those disqualifications, but it's about at least a lawyer of at least 15 years standing at the bar qualifies. You don't have to have been a judge before. You don't have to, right? And all that. You remember Professor Datiba, Modibo Okran, and the rest. They were appointed straight from the private sector and came onto the Supreme Court. So that's not our law. So you don't have to be a judge before. So you see, because now with this, then you see that people are getting angry. What is this? What is this? No, the court hasn't done. The haste was too much. So in the process, then you see you eroding the confidence that people have in the court. Because it's as if Speaker is gone to space or Mars. No. The table number 4 says, look, you will sit any day and time you want. That's what your own decision. That's Yasanto's valedictory judgment when she was leaving. So for Ekufu, this was her last judgment. He said, no, executive can't tell them where they will sit. Public holiday, workers on strike, Saturday, Sunday, they will sit. It's an essential service. So they're saying that justice, okay, the justice system provides an essential service, okay? So they are not bound by these holidays and Saturdays and Sundays. So I expected the Supreme Court to have hastened slowly, give Speaker an opportunity. Then to make matters worse, you see that even the lawyers, when you read through, the lawyer said, I want the order for 10 days.
Yes.
Okay? That's usually the practice for injunctions. When you go ex parte, they usually make it short. Yes. So that you use that period to find the person. So they were talking about Evans and then Apedo, right?
Yes.
So Evans will now look for the bailiff, and then within 10 days, he'll try to, serve this and Apedo to respond, etc. But you see, the lawyer said, I want it for 10 days. The court said, no, it's not 10 days, unlimited.
So because I'm looking at it, the order under which they even applied, and per the High Court's civil procedures,
yeah,
the rules that apply this, it's supposed to be 10 days.
Yes.
But then in the court order, until the determination of the case, that's unlimited.
Yes. So
is that regular?
No, it's not. So you see, let's distinguish this. Theoretically, you can say yes, nothing stops them. But practically, we use, so the ones that they are referring to, that's the application for injunctions, right? Yes, so you find it in the CI 47. When it's ex parte, usually it's for 10 days, okay? 10 days. And then you go and find the other person, the person you get the injunction, the order against. Then you serve him. Because so within the 10 days, he stopped from doing what he's doing. And then he has opportunity, once he's served, to also, so within the 10 days, then you reserve him. You call there's the one we call, you make it on notice. So it means that you serve him with a new application. So it means that there are two applications. One, you come before the court alone. That's the ex parte. And then you show the agency something is being spoiled, something is being destroyed. If we don't stop it quickly, by the time we say we are going to fine him to 7, he would have destroyed it. You can't put it together again. Destroyed beyond redemption. That's a key thing. That's why I said, so for me, between now and Tuesday, what was going to be spoiled beyond redemption? I don't see it. That's why I'm here. People, viewers, and listeners can show. What's the spoiled beyond redemption by Tuesday? That test.
Especially that we are also in the weekend.
Exactly. That test, where is it? So it's when you come and you get that order, so you are going to serve them. But you know that by 10 days' time, if you don't apply for a fresh one, the person can continue doing what he's doing. So when you get the order for the 10 days, you serve him. Then within the 10 days, you prepare a new application. And then go and serve him again. So that one, they will give a further date. and then he will come to court to respond. So that's how it's done. You see it. So, like you heard Ansari, you heard how he was very, very upset with it. You heard the comment. Are you going to play it or you played it?
He's going to be joining us.
Yes.
He'll be joining us.
Yes. With respect, the Supreme Court hasn't done well. As I said, for me, the fear is that now with this, we've allowed lay people, you see, usually we're shy about certain things, but now people are jumping. And you know, it didn't start today. It started some years ago when they started saying, hey, unanimous 7, unanimous FC. You remember? Unanimous FC. You see, when it came to the election petition, those things. So the citizenry started standing up. Of course, it's expected. You see a youth in one kasa who are you bonny. So I remember the day we won the Domlevo case. You know, the one Kufuado and his people were looting and Domlevo sought to right? Then Domlevo sought to catch them, then they sacked him so that they could do that. You know, that's even one decision that the court sat on it. You see, they didn't treat it very urgently like this. Meanwhile, there was a risk of looting. But that one, no. The court was very slow. Of course, at a point, we lawyers also got tired, so we're also contributing to the slowness. But you see, when the court wants to be very fast, it will be fast. But the point I'm making is that on that day, Justice Doche told us, and that was also the day Oliver Samson Ladi Ayenini, and then Professor Apieje Etuya, University of Ghana, they won the case of the imposition, the COVID law that was said to be unconstitutional. So Justice Doche said, Pebu, you and the rest, said today when you go, you will not call us unanimous 7. Today, the public or the masses have won 2 cases against the government. That's the Domlevo case and then the imposition, the COVID law. So the point I'm making is that so the Supreme Court itself is aware that they've acquired that name, unanimous 7. And it's not complimentary. People were not happy. So you see that knowing that, hey, now people are getting up, and so they're beginning to erode their confidence in the justice system. I would have thought that they would have gone slowly. You see, you can come to the same decision, but it's how you go about it. Let the other side come. Because, look, the key thing we should ask ourselves is that between yesterday afternoon and Monday, that's the last day they could have sat on this matter. What was going to be irretrievably spoiled was the irreparable harm. You can't just write in one sentence, we appreciate the urgency. Hey, is that so? Look at the sentence.
Yes, that's the order.
We appreciate the urgency and special circumstances presented to support the filing of this application. The urgency and special circumstances lie in the effect of the impugned ruling, which include, then they go on, depriving the 4 constituencies that the said MPs presently represent, namely, blah, blah, blah. The said 4 constituencies, so let's go to the substance, have the right of representation in Parliament until the next Parliament, until the next Parliament by the said ruling. Let's go over. It says the said 4 constituencies in Ashanti, blah, 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 have been deprived of their basic democratic and constitutional right of representation in Parliament until the next Parliament by the said ruling. So between Friday and Tuesday, what is it? I mean, that's a key thing we should be asking. Because in law, yes, they can give the orders, but you give the orders when the facts, you know, entitle you, when the facts speak for themselves. So what is it that will be lost between Friday and Monday? When even the Tuesday, we know the time Parliament sits. Even if you say there's going to be a Supreme Court decision, so you ask Parliament to this will not start at the right, sit in the morning, but sit in the afternoon. They will do so. You remember at a point in time, I think after the 2020 elections, because a lot of the MPs are ministers, Parliament saw that if they start sitting at 9 a.m., so many ministers cannot attend Parliament, right? Yeah. And so they said people will not be represented. So they had to agree that they will sit in the afternoon. So the minister can go to office, work in the morning and come. So what I mean is that all these things can be negotiated. So I don't see the urgency, with due respect.
And you see the surprise in the speed as well, as some lawyers have.
That's what I'm saying. So that's the urgency, as I said, that's speed. You filed it yesterday. yesterday, and then within that short time, it's been arraigned. Meanwhile, there are cases, people are in custody. That's even more precious. People's personal liberties, they've been in custody for years. Their appeals have not been heard, criminal appeals. That's not urgent. I told you that this country, we don't appreciate personal liberties at all. And yet this one just came within hours. Then the court has gone in. Okay.
So what was the irreparable damage, really, that between Friday and Tuesday, that Parliament would reconvene after taking that break? Reason why your leadership went on this path of having the Supreme Court stay the Speaker's ruling on these 4 seats until the final determination of the case?
Well, Alfred, let me say a very good morning to you once again and to your cherished viewers. I am very much surprised about the commentary from my senior colleague, Pegbu. Clearly, he has not been following the matters in court, because if he has been following keenly the matters in court, some of these comments would clearly, in his estimation, would be unwarranted. Why do I say so? On the day that the Speaker of Parliament was given the ruling, he gave an account as to why he has refused service. This confirms why it is not necessarily about what happens from now till Tuesday. The Speaker of Parliament, because of the anticipation that the majority caucus in Parliament, led by Honorable Fenyomaken, because of that anticipation, had already attempted a number of service on the Speaker of Parliament. Unfortunately, the Speaker of Parliament in his ruling agreed that indeed there has been an attempted service on him.
But he explained why, is it not? I'm sure we all did listen to him.
Hold on, I'm building a point. Alfred, hold on for me. But because, in his estimation, and according to him, a conclave that he had with the Chief Justice, service on members of Parliament and the Speaker of Parliament, by virtue of our privileges and immunities, cannot be served on any other day apart from Monday. Apart from Monday, emphasis mine, apart from Monday. And for that matter, the Speaker of Parliament had refused service. Now my point is, when it comes to service, the CI 47 that regulates service of a process, according to Order 7, when it comes to personal service, you need to direct the personal service, but if the person frustrates the service, you put it as near as possible to the person, which was done at the legal department. Now, the question is, what is the CI 47? The CI 47 is a subsidiary legislation, and it was put together by a rules of court committee as per Article 157 of the 1992 Constitution. Now, if you have your Constitution, you may turn to Article 157 of the 1992 Constitution. I am trying to bring to your notice how the Speaker of Parliament unilaterally amended the 157 of the 1992 Constitution without recourse to the procedure in amending a subsidiary legislation as per the 1992 Constitution. Now, the 1992 Constitution, that is Article 157, talks about the fact that there shall be a rules of committee which shall consist of the Chief Justice, who shall be the chairman, 6 other members of the Judicial Council, other than the Chief Justice, nominated by the Judicial Council, and 2 lawyers. So if you come to the 1572, it talks about the fact that the rules of committee shall, by a constitutional instrument, make rules and regulations for regulating the practice and procedure of all courts in Ghana. So it is the sole responsibility of the rules of court committee to put together the CI-47, which is already in existence, that regulates the procedure in court. And in that CI-47, Order 7 regulates how service will have to be done. Nowhere in the CI-47 can be seen that members of parliament will have to be served only on Mondays. It does not lie in the mouth of the Speaker of Parliament alone to say that there was a supposed conflict between himself and the Chief Justice, and for that matter, members of Parliament and the Speaker of Parliament can only be served only on Mondays. It does not lie in his mouth. Now, if you come
can I ask you that question? No. So you made a point.
Let me just add this one.
So that you don't. It's okay. I would have you proceed. But because you made a point about the Speaker refusing service, when he was delivering his ruling, I recall that Alexander Afenyo-Markin made reference to what you are talking about, that he tried serving him and the Speaker's team, the legal department of Parliament, then indicated that the Speaker had given express instructions that he should be consulted before any suit or service is accepted by the legal team. That's correct, is it not? That's number one.
That is illegal. The Speaker of Parliament alone cannot seek to amend Article 11.7. And that is what I was going to point to.
That's what I was just leading to a question. It was not the Speaker. He indicated that this was after the conclave, as you have made reference to, with the Chief Justice.
And I'm saying that.
And so it is not the sole decision of the Speaker.
Please, don't do that. Don't do that. Lawyer Pebu is a lawyer. He knows Article 11.
But did the Chief Justice agree or not?
Hold on.
No, I'm just saying that if you say the Speaker alone, that's what I wanted to let you know. That the Speaker was, and I know you were in Parliament.
That is okay, but I'm just saying that was his allegation. Listen, that was his allegation. That was Speaker of Parliament's allegation that there was a conflict between him and the Chief Justice. But if you read the judgment from the Supreme Court, as far as the ex parte application was concerned, the Chief Justice and the other 4 members indicated in the ruling that they have taken notice of the Speaker of Parliament's allegation that members of Parliament will have to be served on Mondays. But I just read the Rules of Court Committee as per Article 157 to you, that it does not lie within the mouth of the Speaker of Parliament, neither the Chief Justice or a supposed conclave between the two to amend the CI-47, which is the subsidiary legislation. So if you come to Article 11, the sources of law, that talks about the sequence of importance as far as our laws of this country is concerned. The Constitution, which is the supreme law of the land, followed by the Act of Parliament and subsidiary legislation and what have you. The 11.7 talks about how a subsidiary legislation like the CI-47 can be amended. Now 11.7 talks about the fact that any order, rule or regulation, this is Article 11.7, any order, rule or regulation made by a person or authority under a power conferred by this Constitution or any other law shall be laid before Parliament. This is the procedure in amending the CI-47. The Speaker of Parliament could not have usurped any power or a certain conclave between himself and the Chief Justice per his own allegation to have amended service, that is Order 7 of the Constitution, and say that members of Parliament shall only be served on Mondays. It does not lie in his mouth. And that is why the agency, as we took to court yesterday, lies, because the agency is that we cannot even serve him on Friday. Mr. Pebu, we could not have even served him on Friday because the Speaker of Parliament has made it clear that the Speaker of Parliament,
when you don't find him, you go to court for an order. So when you don't find the person, you file what we call application for substitute service. What are you talking about?
Please, you see? I am saying that. Listen, I am saying that.
But I thought you know. You are not going to reteach me.
No, I am talking about the
You are my student. You are not going to reteach me. Hey, if I was that bad, I'm not sure you'd have passed. You are not telling me that I don't understand.
I am not saying you are that bad. Of course, I recognize the fact that you
haven't taught you. Now you're saying that I'm listening.
I am proud of that. I am proud of that. But my point is that I did not say you do not know the law. I said that you did not follow the sequence in Parliament.
Listen, I said, let me tell you.
Because if you had followed the sequence in Parliament, you would have known that even statutory service in this particular instance wouldn't have helped the cause of the majority.
So what did I say? So I said the court could have made an order that go find give the order straight away, even without an application. That's what I said. So I said between Friday and Saturday, go find speaker. If he doesn't respond, either the court will sit Saturday evening, or the court could have made an order that Saturday after 8 p.m. If you don't get him, then blast it in the mass media. That's what I was saying. The court can make those orders.
Mr. Kwebu, you respectfully are not listening to me.
No, it's not about order 7.
Hold on. Please hold on.
So what is your issue? What's your point, really?
Service has already been done.
No. What was before the court? No, as if wait. What was before the court is the ex parte application. As if did anybody try to serve the speaker with the ex parte application?
No. So the reason why the service does not even come in is that service has already been done according to order 7.
What's the service of what? Let him wait.
Can I have
Vincent.
No, you are misleading us, so let's correct it. No, let me come in because I'm a lawyer. Let me bring this point.
Has service been done in this particular ex parte motion?
This ex parte motion.
No, hold on. I just want to.
What I've said is all true.
Gentlemen, hold on.
I'm telling him that listen to me, Alfred. Substituted service does not even come in because in our estimation, service has already been done because order 7 says.
Did you serve of the application?
Hold on.
Oh, please listen to me. Can you listen to me? I'm saying that.
Service of what?
The person prostrate service.
Of what?
Wait.
As near as possible to him. The Speaker of Parliament in his ruling indicated, and Market on the floor of Parliament said that the process was thrown at the legal department. Please, did you hear that or you did not hear that? Is that not service? If it is thrown at the person, that is service. So, even statutory service does not even come in here. But I am pointing to you that the conduct of the Speaker of Parliament and the legal department allowed us to protect the sanctity of Parliament, to protect the sanctity, and if you like, the representation of the 4 constituencies by going ex parte to the Supreme Court to make sure that we stay execution so that the status quo ante will be restored for us. And so it is not wrong for us to have gone ex parte motion.
The question is, you talk about service being done. In that particular instance that you reference, what Afenyomakin himself resisted vehemently when the speaker said he threw it. He said he did not do that, and that is a matter of his integrity. If you were not in Parliament, maybe you missed that point.
Please, I did not miss that, but I'm saying that the Speaker of Parliament himself was not at the legal department.
Okay, but if you say,
it is an account of what he has been told, and Afenyomakin made it clear to him that he may have been told things that are not right.
So, but he refused and refuted the fact that he did not go in there to throw it. And you are saying that this morning that throwing a suit or this particular application, it amounts to service in that form.
As near as possible. That is the dictate of CF order 7.
And as near as possible, where exactly did he serve the speaker?
At the legal department.
And did the legal department?
Because the Speaker of Parliament himself has said that you cannot serve him personally, but take it to the legal department.
Good. Did the legal department receive that particular service?
That is why I'm saying that there has been frustration on the part of the legal department.
So was there service or not? Because you said
yes, because it was left as near as possible to them. Yes, it was left at
you are saying that the legal department did not receive the service. And now you're saying service has been done. So how do I reconcile the two?
Yes, because the law says that if the person refuses service, leave it as near as possible to the person. And that is service.
Did they leave it at the legal department?
I'm suggesting to you that was that.
What was it? And I just want to make a point. And because the Speaker was clear in his ruling that he had directed the legal department not to accept any service until he is consulted. Until he is consulted.
But the Speaker of Parliament does not have the law in his bosom to decide.
But he is the leader of Parliament.
So he should trample upon the Constitution.
Mr. Okansi, let's come in briefly here. Listen, as if are you aware that what Avenue Markin sought to serve the first time is different from what was filed yesterday? This one that the Supreme Court sat on yesterday, it was filed the same yesterday. It was filed the same yesterday, probably even afternoon. It wasn't 9 a.m., not 10 a.m. What they dealt with yesterday was filed yesterday, and within hours, the Supreme Court sat. So my point is that is the one, because it's different in nature from the first one they sought to serve, the court should have given an opportunity. What was dealt with yesterday was filed yesterday. That is what I'm telling you. Beyond 10 o'clock, it was probably in the afternoon from the estimation, and we can get the exact time, but it wasn't 9 a.m., it wasn't 10 a.m.
Okay.
It wasn't 9 a.m., it wasn't 10 a.m. It was filed the same yesterday. Who attempted to serve that on the Speaker?
Mr. Martin,
yes.
My lecture that I am so much pleased.
Yes.
I'm saying that yesterday was a Friday.
Yes.
And so the Speaker of Parliament has already indicated that if it is not Monday, I'm not taking any service.
Oh, please.
Why do you
don't do that? I said, well, you haven't practiced much. That's why you're doing
If I am your client, Mr. Martin Bebu, will you advise me?
Don't do that.
The Speaker of Parliament who has already said that I won't receive service on Friday, you still go and serve it. You can use other means to block the ruling.
Let me tell you, the way it goes is that once what was attempted to be served, that earlier application, we were looking for an injunction earlier on, right? And then they couldn't serve, they couldn't get the court, etc. It's different from the application that was filed yesterday, probably close to noon, and then within hours.
This ex parte motion.
Yes, this ex parte one is different from the first one. So the first one, what we do is that you apply, there's a mother case, let me call it a mother. A mother gives birth, right? So there is a case that you've taken to the Supreme Court. Then on the back of it, you mount an application, either for injunction or whatever. So there are two. So that's why they try to serve first. And from what the Speaker is even saying, it means that he says the Chief Justice agreed. He says he's even a directive, blah, blah. You, for now, let's leave that for Mr. Speaker and Chief Justice.
Mr. Martin, my lecture that I'm well pleased, you think that the Speaker of Parliament can do so, and you serve the powers, so if you like, you serve provisions in the Constitution and provisions in the subsidiary legislation?
What I say, if it's agreed under practice directions, you think everything that is in the practice directions,
according to Article 11, please,
that's not the occasion for this.
Gentlemen,
if the Chief Justice agreed, you as if what do you know what went into it? Do you know what went into it?
So, gentlemen,
if the Chief Justice agreed, you know what went into it. That's why I said we'll leave that. Otherwise, we'll obfuscate matters.
Thank you. Thank you. Now,
Mr. Martin Bebu, the justices are not bigger than the provisions in our Constitution. It doesn't matter what was agreed in the conclave. The Constitution is supreme. Article 1 tells you the Constitution.
So you don't know that if you agree something with somebody and you want to change, Ketsi at least would demand that you put him on notice that I'm no longer going by this agreement. What are you saying? What are you saying? What are you saying? So you can agree something with somebody, then you go behind the person and do something different.
I hear lawyer Sefua, I hear you continuously refer to this conclave that was agreed per the Speaker's declaration as an alleged conclave. Are you saying that you know that this conclave or this agreement may not have been had between the Speaker and the Chief Justice on the period of service?
I am only saying that that conclave cannot surmount the provisions of the Constitution. Please, that is what I'm saying. And Lawyer Martin, people cannot deny knowledge of this.
But it's about the procedure. So if you've agreed with somebody and then later you think that thing is wrong, you just go ahead, roughshod.
Okay.
Won't you put the person on notice that, look, listen, I'm resiling from it. So that's why I said the court could have given another opportunity. So they would then in the
has already indicated to you that when you come by way of notice, I am not taking your service because it is not a mandate. This is what happened in court.
The other one, Mama Yariga, is also an officer of the court. And
he's senior to all of us, so who knows?
And senior to all of you, lawyers here on this platform. Yes. Now, having listened to this particular issue about, there was a specific declaration by the Speaker as to why service had been agreed to be done on a particular day. And I understand the background and foundation for that was previous instances where officers of the court would accost speakers of parliament, that's the members of parliament, even on their way to parliament in their homes and so on, and then they would have to tell them that they are going to do parliamentary business and so on. What was the basis for this particular conclave, and what Vincent Asifua is talking about, that it can be set aside because of a particular situation?
Well, thank you very much. I have listened patiently to my two colleague lawyers as they banter, and then my colleague member of parliament. I think that if you give me the permission, I probably will not spend too much time on this simple question, because it is anchored on Article 117 of the Constitution of Ghana. And the article says, civil or criminal process coming from any court, I repeat, any court, I repeat again, any court or place out of Parliament shall not be served on or executed in relation to the Speaker or a member or the clerk to Parliament while he is on his way to, attending at, or returning from any proceedings of Parliament. So Article 117 is very clear that once Parliament is in process, once a member is on his way to Parliament, is attending at Parliament, on his way from Parliament, the clerk of Parliament, the Speaker of Parliament, you cannot serve any process on any of them. The Constitution is very clear on that matter. So the issue that came up on Tuesday was that Afunimakin tried to serve, and we are told that the officials at Parliament rejected the service. And he came to the floor, and when the then minority leader raised the issue and he rose to speak and comment, he then drew attention to an application that he had brought before the Supreme Court and how he had attempted to serve that and how the officials in Parliament were refusing service. Then he attempted to lay it and make it part of the records of Parliament. And the Speaker rejected that effort and insisted that he, the Speaker, had come to an understanding with the Chief Justice that to manage the challenges posed by Article 117, to manage the challenges posed by Article 1, otherwise they couldn't have served him anyway. And in fact, the Supreme Court should have known that the service was wrong. If really we are going to go by the Constitution and not the rules of court. The rules of court are subsidiary to the Constitution, subordinate to the Constitution. I get the situation. So the Speaker said to have some amicable understanding with the Judicial on how to manage the challenges of serving parliamentarians. So it doesn't look like parliamentarians are above the law. Are you getting the situation? I have made some concessions and we've agreed that on Mondays we don't sit. So every process that they want to serve should be served on Monday. Okay? If that is the understanding with the Chief Justice and practice directives have been issued to that effect, then it would have required that if they were going to serve again and it wasn't a Monday, there had to be substituted service or some service based on a directive of the court, that even though this is the understanding and the practice direction. Is that okay? We are making an exception that go and serve them on this date or that other date. That is the very simple thing that should have happened. But like I said, for me, service, no service, whatever happened, I am scandalized. I am sad. And I'm sad because I'm one of those who sat as a member of the appointments committee and processed these people to sit as Supreme Court judges. Some of them, maybe not all of them, maybe one or two of them, I wasn't part, but some of them. And I thought that when they came, they committed themselves to interpret and enforce our Constitution. And I assumed that they understood the Constitution. I assumed. Why do I say so? If you listen to the ruling, I didn't listen, but then I got a copy of the ruling. If you read the ruling, you see that they are saying that the matter before them is a human rights matter. I don't know if you have read it. They say it's a human rights matter and the rights of the people of these 4 constituencies to be represented. Is that okay? And the rights of the MPs to represent those people. That's what they say. That it is about the representation of those constituencies and the rights of the MPs to represent those constituencies. So essentially, the Supreme Court is saying that it is a human rights matter that is before them. It's a human rights matter. And I ask myself very basic questions that a first-year constitutional law student will ask. If it is a human rights matter, whose right was violated? Was it Afenyomakin's right? Does Afenyomakin come from any of those constituencies? Is Afenyomakin one of the members of parliament? If he is not from that constituency, has his right to be represented been violated by anybody? If he is not one of the members of parliament, has his right to represent constituents been violated? So where is the locus of Afenyomakin to be making an application in this matter?
Will he being the leader of the NPP caucus in parliament suffice in that capacity of he being a party to this case?
You see, if it is a human rights matter, the Supreme Court itself has no jurisdiction. Because Article 33 of the Constitution is clear on the protection of rights by the courts. And Article 33 says that where a person alleges that a provision of this Constitution on the fundamental human rights and freedoms has been or is being or is likely to be contravened in relation to him, then without prejudice to any other action that is lawfully available, which could be like going to the Human Rights Commission, etc., is that okay? That person may apply to the High Court for redress.
Right.
So if you are talking about human rights and the right of the people to be represented and the right of the MPs to represent their people, strictly speaking, you go to the High Court. Say, hey, my right is being violated. So one, Afenyomakin has no locus because it's not his right that is being violated. He is not a representative of those constituencies, and he's not a constituent of any of the MPs. And the Supreme Court has no basis because you say it's a human right and that the right of the people to be represented is being violated, and therefore that is what you are intervening to protect. And that the right of the MPs to represent their people is being violated and you are intervening to protect those rights. So the Supreme Court got it totally wrong. There's a simple issue. I'm further scandalized because
by what?
When I read the judgment, the ruling of the court and the orders, they say that the applicant says there will be chaos in this country. That there will be chaos in this country. That's what the Supreme Court says. That the business of government will be stalled and disrupted, and the running of this country will be disrupted because members of the minority in parliament are likely to go and take over their position as the majority and restructure committees and etc. This is what the Supreme Court says. And that because of that, they are intervening to stop whatever is going to happen in Parliament. By reversing the decision of the Speaker and by ordering that those 4 MPs should go back to Parliament. And I say I'm scandalized because I assumed that the people that are participated in processing and approving to be Supreme Court judges understand the basic concept of the political doctrine question.
The separation of powers.
Yeah, the political question doctrine of the Supreme Court of the United States. Where the United States Supreme Court in Baker and Carr in 1969 set the principle. And I always cite the US because we are copying our constitutional jurisprudence from the US. The whole concept of separation of powers, are you getting the point?
Yes.
You know, and judicial review and etc. Started from Marbury and Madison and etc. So we pick from their jurisprudence. In Baker and Carr, the Supreme Court in the US was very, very clear that the political question doctrine does not allow the Supreme Court to hear cases that are within the province and discretions of the 2 political branches of government, which is the executive and the legislature. It is entirely within their discretion what they do politically. How, in the exercise of our functions in Parliament, we prevent government from pursuing its business. It's not the business of the Supreme Court. We prevent government from pursuing its business by voting, by arguing, by applying our rules. If we apply our rules according to the rules, and in the process we prevent government from pursuing its agenda in the House, it's purely a political matter. How does the Supreme Court turn itself into a political organization to supervise the exercise of the political actions of political actors in the legislature? And they said it clearly. They said, read it. Read the ruling. They said that the MPs on the minority side are planning to reconstitute committee. Is that your business?
So, yes, I think that...
Are you getting the point? Now, let me go to another matter which the Supreme Court said in giving its directive. That the MPs were not heard. That the MPs were not heard. By who? By Parliament? The MPs are members of Parliament and were obliged to be sitting in Parliament on the day they were debating the matter. The MPs, they are members of Parliament. They were obliged to be sitting in Parliament the day we were debating the matter. Why were not they? Why were they not there? They were not there because they themselves know that they have violated the Constitution. They were not interested in the matter. Their issues had come up for debate and they were not interested. Why were they not interested? Because they knew very well that they themselves had engaged in the conduct that they engaged in. So how can the Supreme Court be interfering in the business of Parliament and telling us that the MPs were not heard? Because the MPs were not heard, they are cancelling it. Who says the MPs wanted to be heard? Where have any of the MPs complained that they were not heard? They didn't want to be heard because they knew what they had done. So I am scandalized, I am shocked, I am totally disappointed that the Supreme Court will stoop as low as they went in this instance. They are governed by the Constitution. Indeed, I said it on FM yesterday that so far as I am concerned, the Supreme Court, constituted by these 5 judges, had violated provisions of Article 115 and 122 of the Constitution, which provisions say that no one shall interfere with the proceedings of Parliament. Let me read it. No one shall interfere with the proceedings of Parliament. an act or omission which obstructs or impedes Parliament in the performance of its functions, or which obstructs or impedes a member or officer of Parliament in the discharge of his duties, or affronts the dignity of Parliament, or which tends either directly or indirectly to produce that result, is contempt of Parliament. There are two constitutional bodies that have contempt powers: the courts and Parliament. The courts, they say they can hold parliamentarians before them for contempt, and they've done that with my colleague, Honorable Ayine, if you recall. He got in the situation. Yes. Same way, Parliament can also hold them before it for contempt, because the contempt powers are given to Parliament. And what will constitute contempt in some cases? Freedom, privileges, and immunities. There shall be freedom of speech, debate, and proceedings in Parliament, and that freedom shall not be impeached or questioned in any court. In any court, that freedom of proceedings of Parliament shall not be questioned or impeached in any court or placed out of Parliament.
I see. So,
any court or placed out of court, even the Supreme Court.
So if the court
let me land. I am saying that what the court did on Friday is absolutely absurd, both in terms of the process they use, because people have argued the whole issue of the process. I don't want to repeat that. The whole issue of process, I mean, how the speed with which they were able to convene and do the bidding of Afenyomakin. I mean, unbelievable. Afenyomakin, to be able to railroad the Supreme Court to act with such dispatch, when all the chief imams and imams, all the pastors, all the leaders, all the religious groups have been begging this Supreme Court to take a decision in relation to the LGBTQ question. And the Supreme Court has refused to take a decision. And yet, Afenyomakin alone was able to get this Supreme Court. And that is why people must rethink and think carefully about December 7th and what they are going to do.
One man.
So I am shocked that Afenyomakin, the Supreme Court allowed itself for Afenyomakin to railroad them, to hasten and violate the Constitution and mutilate it in the manner that they did, because there was no basis for what they did. There's no such agency. There's no emergency. And let me assure you that Tuesday is going to be an interesting day. Tuesday, when Parliament resumes, it's going to be an interesting day. I'm serving notice that Tuesday is going to be an interesting day.
If you say it's going to be an interesting day, what should we expect?
I say it is going to be an interesting day.
There was something that you said earlier. So if the courts, based on the references you made, should stay true to its original jurisprudence, the expectation is that the court's mandate in terms of any application brought before it now will have to be limited to determining the correctness by which, or rather to indetermine the propriety by which the Speaker exercise his mandate.
Let me give you what the proper position of the Constitution is. Yeah, you see, I'm interested in constitutional law. Is that okay? I'm interested. You can go and ask my lecturer, Kofi Kumado, in constitutional law. People say Harvard. No, I didn't learn my constitutional law from Harvard. Yeah, I did constitutional law at Harvard. I got, taught by one of the best, Lawrence Tribe, who was Al Gore's lawyer. But for me, the foundation of my constitutional law comes from the teaching of Professor Kofi Kumado, who I'm very proud of as my lecturer. I always take my time and read the wording of the Constitution. And I always ask lawyers, please pay attention, because it is written in English. Is that okay? If the English raises doubts because of application to facts and circumstances, then we can deal with that. But the basic thing is that it is in English. Read Article 2. It says that a person who alleges B, any act or omission of any person is inconsistent with or is in contravention of a provision of this Constitution may bring an action in the Supreme Court for a declaration to that effect. For a declaration to that effect. 2.2 says, the Supreme Court shall, for the purposes of a declaration under Clause 1 of this article, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to the declaration so made. Giving effect. Enabling effect to be given to the declaration. So the first thing is, your mandate is not to interfere in the work of Parliament and suspend their decisions. Your mandate is to declare whether or not what Speaker did is in violation of Article 97, 1G of the Constitution. Period.
That's
judicial review. Are you getting the point? If you so declare, then you can now make orders to give effect. But somebody comes to you and says, oh, Parliament went through all these processes and then did some things and I think it's wrong. They say, no, Parliament, please suspend your decision. Don't enforce it. Give me time to now make a declaration. No, it doesn't. It's not ordinary land litigation like Kwebu has tried to explain. Land litigation. And this is a constitutional matter governed by the clear language of the Constitution, because you don't take one clause, Article 2, and so I'm acting on Article 2. You must read Article 2 in relation to Article 115, in relation to Article 122, in relation to the entire chapter of the provision on the legislature and the powers of the legislature and the sovereignty of the legislature, though limited in the context of our political architecture, not like the British parliamentary sovereignty doctrine. Are you getting the point? Yes. Limited. So you must read the entire Constitution. Not just pick Article 2 and then be running and say, oh, I'm interpreting the Constitution. Anytime I'm interpreting the Constitution, I have all the powers under this sun to treat Parliament like I'm treating an ordinary land litigant.
Well, so in terms
it doesn't work that way.
So in terms of its own jurisdiction and the jurisprudence, Mama Yaga, the Supreme Court cannot in any way determine the correctness of the Speaker's interpretation of the law. They cannot do that. It is not within their jurisdiction to do that.
They can it's not even, the Speaker didn't interpret the Constitution. The Speaker acted. The Speaker acted on a provision of the Constitution to enforce it. Are you getting the situation? And he was clear. He said, I'm not interpreting the Constitution. I'm just enforcing a provision of the Constitution as I understand it. Don't forget that every single one of us, the legislature, the judiciary, and the executive, we first have to read the Constitution and understand it the way we understand it and act. Are you getting the point? Mm-hmm. So, INET in the process of enforcing the Constitution is an interpretation in your mind of it as you read it. What does it say I should do? Mm-hmm. Is that okay? Mm-hmm. But the people with the final authority to interpret it are the Supreme Court. It's not that others don't have jurisdiction to interpret. You have to interpret before you can act on it. You interpret to understand it so that you can act on it. But then when your interpretation and action is challenged, then that becomes the province of the Supreme Court. So the Speaker was not engaged in the process of interpretation. He was saying, look, this is my understanding of my duty under the Constitution, that when A leaves this party and goes to this party, he leaves this Parliament. If he leaves this party and goes independent, he leaves this Parliament. If he leaves independent and goes to this party, he leaves Parliament. That is my understanding of it, so I am enforcing it. Now, you go to the Supreme Court. The Supreme Court is supposed to say, well, you know, let's interpret Article 97 1G for you. This is what it actually means. Mm-hmm. At that point, we will all be bound by a decision of the Supreme Court. Now, the Supreme Court says that it is absurd for people not to have representation. Let me tell you that the people of SAL did not have representation for 4 years. The Supreme Court was not bothered. They were not bothered.
Yeah.
And the people were sad, not human beings. And let me say that. Let me also add that if I think 6 months to elections, is that okay? A member of parliament resigns or dies or something of that sort.
3 months.
3 months to elections. The same constitution does not allow us to hold
Article 112
an election.
Yes.
Is that okay? So the constitution has itself created a situation and circumstance where it tolerates an arrangement where some people may not be represented in parliament. So you cannot be crying more than the bereaved. You, the justice, cannot be crying more than the constitution itself. The constitution is clear that there are some circumstances where the constitution, permit that some people should not be represented in parliament.
Oh my God, I'll have to leave us. But I asked this question based on the premise in this, the court ruling yesterday. There's a point E. It says Exhibit B, the ruling on page 3, in doing so. Clearly, the Speaker of Parliament was usurping the original and exclusive jurisdiction of this honorable court, and he himself recognized this, as in his attempt or effect to try and interpret the Constitution. If you listen to the argument of Alexander Fenner-Markin, and in fact, it's in tandem with what the Supreme Court justices have captured in this particular decision, his contention is that per the Speaker's decision, he sought to interpret the law. And you had indicated clearly, and we all listened to the Speaker when he was reading his decision, that he did not seek to interpret the Constitution, but apply Article 97 as the dictates are. And per the reading, as you put it, Article 97, per the details, is an authority that is vested in the Speaker as the ultimate presiding officer of the House, correct?
Yes, yes.
Exactly.
Okay. So the Speaker has a mandate to take decisions by way of determining things that affect his mandate.
Exactly.
So what went wrong here?
Absolutely nothing. And the Supreme Court struggling to make sense out of what didn't make sense. Struggling to make sense out of what didn't make sense. Because you see, Afenyo-Markin, and people made mention of something, because sometimes when a matter is so useless, I don't really even pay attention to the details of a useless affair. Why do I say so? I heard long before we even resumed that Afenyo-Markin was running to the Supreme Court to try and then injunct us from stopping the Speaker from declaring the vacancy of those 4 seats. So if you recall, on the floor of the House, we argued that, but Afenyo-Markin, you've run to the Supreme Court to injunct what has not yet occurred. You see, it amounts to asking the Supreme Court to give an advisory opinion. Wait till the facts occur. Do you get it? When the facts occur, then you now go to the Supreme Court. But Haru now stands on the platform in Tamale and says, we will do this. We will take steps to make sure that the proper composition of the House prevails. Then you run to court. When we haven't resumed Parliament, we haven't sat in the chamber, we haven't taken the steps to actually create the set of circumstances and facts that will give a basis for you to take legal action. So the question is, he now claims, and they are claiming that they attempted to serve us, because you see, Kwebu, they are saying, the judges themselves are saying that there was an attempt to serve us. Yes. Which one?
That's what I said. So that's
it must be the original case that Afenyo-Markin sought to institute when the facts had not arisen.
Yes, that's what I was pointing out to Asifua. So that's
are you getting the point? And so the Supreme Court should have told Afenyo-Markin that, but this your thing, you filed it on this date, and by that date, the facts that you are bringing and asking us to work on had not occurred.
That is the point I was making to Asifua.
Are you getting the situation?
They are different.
And this is the argument that we made in Parliament, that the matter hasn't arisen. So why are you running to court, and why are you already holding an injunction, and why are you seeking to serve Parliament, on a matter that has not arisen? That's preemptive. Is that okay? Yes. That's anticipatory, and it is just legally
but it doesn't
wrong.
mean I cannot serve a process.
So basically, those are the issues that I have to point to. I think that this is the most flawed conduct by our Supreme Court, and it is embarrassing. There are other matters which I won't say on air. I'll leave that to Tuesday, and on Tuesday, when we get to the House, we will see what happens to the directive of the Supreme Court, and we will see whether parliamentarians, including myself, will also be drawing the attention of Parliament to Article 115 and then 122 and its consequences or not. We are all acting based on the Constitution. Yeah. It's not only the Supreme Court that is a body under the Constitution. Parliament is also a body under the Constitution. And the presidency is also a body under the Constitution. We all have our powers and rights under the Constitution. And we're all going to exercise those powers and rights under the Constitution.
Well, because
Alfred, I would want to make a comment before he leaves.
Just a quick one. Very quick one. Yes.
So, number one,
I want to establish this.
So,
hold on, gentlemen, hold on. I want to find out. So, you make your point, but I want to find which particular case were you seeking to serve on the office of the Speaker, which was not accepted?
Obviously, the interlocutory injunction, and not any expert motion as they seek to say. When they listen to me very well, and you see, Honorable Ayariga make mention of the fact that.
But you are saying he had been said.
The fact that
what was he said with?
Hold on. The fact that it is even anticipatory is going into the substantive matter. It does not deny me my right of filing a suit in court so that it will be said. That is number one. Number two, the Honorable Ayariga is saying that when it comes to issues of fundamental rights, as has been enshrined under Chapter 5, nobody can, as it were, bring it upon himself to ensure, if like, enforce fundamental human rights of other persons. Yes, Article 33 talks about the fact that when it comes to fundamental human rights, it is the person who has been affected. But also, a J. Ampofo versus the Attorney General also made mention of the fact that you can also enforce rights or like fundamental human rights of persons by not going to the High Court but the Supreme Court. That is also a constitutional requirement that you can do so. It does not mean that the fact that it is fundamental human rights, other persons cannot go to the Supreme Court to enforce the constitutional rights of such persons. So it is never true that when it comes to fundamental human rights, other persons cannot go to the Supreme Court to enforce those fundamental human rights. A J. Ampofo is a classical case that talked about the fact that when it comes to fundamental human rights, other citizens can go to the Supreme Court to enforce fundamental human rights of such person. So it is never true that the four
it's members not an open bracket. Have you read the service Attorney General? That's where they started.
Is it not an open chat?
No, reference. But I'm saying that when the Honorable Ayariga says that nobody can go to court to enforce fundamental human rights of other persons, and I'm just saying that it is not true, because I, as a citizen, can go to court to enforce the fundamental human rights of Honorable Hassan Ayariga and Lawyer Martin Pebu on the premise that I believe that this is an issue of public interest, and I will not go to the High Court. I will rather go to the Supreme Court to enforce the fundamental human rights of such persons. That is the point I'm trying to make. Number two, when the Honorable Hassan Ayariga talks about the fact that if an MP is going to Parliament or a Speaker of Parliament is going to Parliament and a Clerk of Parliament is going to Parliament, those persons cannot be served. Please, the issue is not about whether the Speaker of Parliament was on his way going to Parliament or an MP was going to Parliament. No. The issue has been the directive from the Speaker of Parliament that when you want to serve me, serve the legal department. The legal department and the personnel that works from the legal department does not fall within the catchment area or the category of who a member of Parliament is, who a Speaker of Parliament is, or who a Clerk of Parliament is. So such persons can be served. And in this particular instance, those persons were not served when they were on their way to Parliament. Indeed, they can be served even when they are on their way to Parliament because they do not fall within that catchment area. But these persons were served at the legal department. So that is the point I want to make. And lastly, It is also not the case when Honorable Hassan Ariga says that no one shall or no one can interfere in the proceedings of Parliament. It is not the case. The Constitution of the Republic of Ghana espouses separation of powers. When it does so, it means that the Supreme Court, when there is a question before it about a procedural breach as far as the workings of parliamentary proceedings is concerned, regarding issues of interpretation, the Supreme Court can assume jurisdiction and interpret the Constitution.
But in this instance...
So that does not amount to interfering in parliamentary proceedings. The Supreme Court has exclusive original jurisdiction when it comes to the interpretation of the Constitution of the Republic of Ghana.
Lawyer Sevoa, did the Speaker interpret Article 97, or as he was clear in his words, he sought to apply?
I do not think that the Speaker of Parliament honestly interpreted the Constitution of the Republic of Ghana. Why? So we have the Republic versus Bikenkan, where any court, even the lower court, can apply the Constitution of the Republic of Ghana when they deem the provisions of the Constitution very clear and unambiguous. But the point we are making is that if the Constitution is being applied in a way that will affect fundamental human rights of other persons, that will deny representation of persons from these four constituencies, then it lies within their rights and other well-meaning Ghanaians to make sure that these kind of application of the law that would deny their representation will be dealt with.
But if you do not think that the Speaker interpreted the Constitution, then where lies the jurisdiction of the Supreme Court in this particular case?
But the fact that the Speaker applied the Constitution in his own understanding, if you read his own ruling, of course, he being an experienced lawyer, was very clear when he said that I am not interpreting the Constitution. He said so, and I will be very honest with that. He said that he's just bringing about his understanding of the Constitution. That means that he's applying the Constitution, which he has that right under Republic versus McKinnon. But I'm also telling you that when you apply the Constitution in such a way that it affects the fundamental human rights of persons, it breaches natural justice, it brings about some amount of illegality, then you can invoke the supervisory jurisdiction of the Supreme Court.
No, but not supervisory jurisdiction here.
But
there's judicial review.
Sorry, you can invoke the judicial review of the Supreme Court. That is the point I'm trying to make. You can go to the Supreme Court to ask for interpretation.
Okay. Don Mama, you wanted to, because you have to leave us.
I unfortunately I have to leave you, but I've really made my point, and like I said earlier on, there was really no basis for whatever happened yesterday. I believe that the Supreme Court, constituted by those 5 judges led by the Chief Justice, clearly exceeded their powers in suspending a decision of Parliament that they had not declared as being in violation of any provision of the Constitution. The Supreme Court has not said that, the Speaker's interpretation is wrong. The Supreme Court has not said that. The Supreme Court has not said that the Speaker's decision to conclude that when you file to contest as an independent candidate, when you are a sitting member of Parliament on the ticket of a political party, you lose your seat. The Supreme Court has not yet said that that is right or wrong. Are you getting the situation? And yet, they interfered with the proper functioning of Parliament by going to suspend that decision. You haven't said the decision is wrong, and yet you have suspended it. On what basis? On the basis of what authority are you doing that? If we allow you to suspend this one, which other decision will you not suspend? So every day we go and sit, we are not sure whether this decision that we have taken today, the Supreme Court will suspend it. Is that how the democracy is supposed to function? And your power is to declare that we are either wrong or we are right. So if you declare that we are wrong and therefore you are annulling our decision, fine. But to suspend our decision, on what authority are you suspending our decision? If you are in a hurry, you could have just done the interpretation yesterday and given your ruling yesterday. You could have done that yesterday. But for Parliament, we to meet and take a decision, then you will suspend it. How? How can that happen?
What the Supreme Court cannot do in this instance, what you're saying is to second guess the Speaker by determining whether or not his application of the law in terms of the determination of vacancy, whether the Speaker has properly done so or otherwise. So that's the fine line we're saying here.
No. When the Speaker enforces a provision of the Constitution by taking a certain action, that is to say that you are a sitting member of the MPP in this House, and you have gone to file as an independent. By my reading of Article 97, 1G and H, you have vacated your seat, so leave this chamber. Is that okay? When the Speaker does that, the Supreme Court can, when somebody goes to them for a declaration, declare that, Mr. Speaker, you are wrong. I get the point. When somebody, a certain member of Parliament on a political party ticket goes to file as an independent, it doesn't amount to vacating the person's seat. So I'm annulling your decision. I'm declaring that your action is null and void. That's the declaration. That is not what happened yesterday. What happened yesterday was the Supreme Court hasn't declared that his decision is wrong. Are you getting the point? But has interfered in his work and suspended his decision. And I'm saying that we're a coordinate arm of government. We're either wrong or we're right. But you have no business interfering in our work. And it is the same Constitution that establishes your office and that says that you are Supreme Court. That also says that when we are working, you shouldn't interfere in our work.
And this is until the determination of the case. So that's indefinite.
Yes, exactly.
Is that regular?
Exactly.
Is it regular to have an ex parte motion run indefinitely until the determination of a particular case?
I am even saying that in this instance, the whole idea of an ex parte motion and etc. is wrong, is flawed. Because you need to act on the basis of the fact that this is a special situation where we're dealing with the architecture of government, where you have the Supreme Court, you have the executive, and you have the legislature. Is that okay? And then you have clear provisions of the Constitution that says, hey, when the legislature is doing its work, I beg you, don't interfere. If you interfere, it amounts to contempt. Clearly stated. Are you getting the point? Clearly stated. I'm saying that under our Constitution, there are only two bodies that the Constitution protects from their work being interfered with. Okay? That is the legislature and the executive. Sorry, the judiciary. And there are two bodies that the Constitution gives the power of, punishment for contempt. And they include the judiciary and again the legislature. So that protection that the Supreme Court seeks to give to the legislature is a protection that the Supreme Court must respect. The same way that the Constitution also gives the judiciary some protection that we also respect, such as the clear provision of the Constitution that when there is a matter that we cannot pass a judgment, we cannot pass a law reversing a judgment of the judiciary. Is that not it? It's in the Constitution. Yes. So it's a protection given so that the judiciary will not take a decision. They will come and sit and say, we don't accept this. Let's pass a law that says that what the courts have done is wrong. We will not abide by it. So these are protections given under the Constitution. And the judiciary must be mindful of those issues. And I'm saying that whole argument that the business of the House will be disrupted, that government cannot do its business, that there will be a crisis in the Parliament, it has nothing to do with the Supreme Court. These are political matters. And Baker and Carr is clear that the Supreme Court should not get itself and should not dabble in political issues. Leave the coordinate branches of government that are political in character to deal with their matters politically. Why? If we go to the House and 2 or 3 MPP members of Parliament don't show up, we can still disrupt government business by voting against it. We can disrupt government business by voting against it. will you come and say, oh, because government business was disrupted, there's a violation of the Constitution? So these are political matters that the Supreme Court should not be bothered, should not get involved in. That's my basic underlying point. That don't allow them to come and frighten you that, and there will be chaos in Parliament. Why chaos? It is the rules of the Constitution that are being interpreted. When, what's his name, Professor Michael Quay gave the ruling, Afemaki was in the house.
Yeah. Well, now they say it's
Joe Garte was in the house. Listen, Joe Garte was in the house. Is that okay? All those who were making noise, they were in the house.
Politics of convenience.
Is that okay? Yeah. They didn't see that there will be chaos. They didn't see that the business of the house being disrupted. I mean, today, all of a sudden, the same provision, the same set of facts, the same application by a speaker, and then all of a sudden there is chaos, there will be confusion. If that confusion occurs, it is going to occur because of what the Supreme Court has done.
Are we faced with a constitutional crisis?
Why?
No, from Tuesday.
I am saying that don't be in a hurry. Tuesday is coming. When Tuesday comes, we will see what will happen. Don't be in a hurry.
The tail of a lion.
I'm saying that don't be in a hurry. Tuesday is coming. Tuesday we will see.
Mahama Yariga is MP for Boko Central, and but Dr. Pagre Boache Tankwa, because you are not a lawyer, obviously following the conversation. We are at this point because essentially your party took a decision, is it not? Prior to the 2020 elections, and now you describe that decision that you found comfort in as unlawful. And so you do not recognize the precedents that has been set. And as a result, you would want to challenge the Speaker's ruling based on the precedent that was set that favored you. Why are you doing this?
Mr. Okansi, is it possible to make a small intervention?
Brief one. With your permission.
I'm
not the host. You are in charge.
Yes. So, as a FUA, you were doubting the existence of the secular. You say
I actually have it. Yes. So I have it. We're going to put out the secular.
12 July 2024 under the Speaker. Okay.
I'll show it. So
the hand of the Judicial Secretary.
You know, Alfred, it's a very interesting morning of law, interpreting the law, the 1992 Constitution, the rights of Parliament. You know, it reminds me of theologians arguing the Bible and imams arguing the Quran. Because, you see, whichever way you take it, right, one has to be able to make a case that is constructive enough to the spirit of the letter. At the start of all of these debates about the NDC wanting to become the new majority and moving the democratically elected majority of the New Patriotic Party into a purported minority was very absurd for me. Very, very absurd, just to start with. And I'm clear in my mind that the suspension that the Supreme Court has placed on the reasoning of the ruling that the Speaker gave would bring a lot more clarity, because where you find misinterpretation, lack of clarity, you need to pause and allow a broader conversation. There are a few cases in reference that I would quote here. You know, Ampofwe J versus the Attorney General stated very clearly that the Supreme Court has concurrent jurisdiction in the enforcement of the fundamental human rights when it does not affect the person applying to the court personally. But when it affects you personally, then the High Court is the forum. So the majority leader, the Honorable Afenyo Markin, is clothed with that capacity to pursue the matter under the 1992 Constitution, Article 2, Clause 1 of 130. So clearly for me, you know, Alfred, when you look at all of this, it's a clear mandate of the majority in Parliament continually exercising their rights and franchise. I don't think that the minority in Parliament, which is the NDC, have earned that right from the bigger constituents of the Ghanaian people to be the majority. I don't see that. Because you see, Alfred, people have gone for elections. They have been voted into office to represent the interests of their constituents. Clearly, within the space we find ourselves, a few more days to a democratic election, which is to be held, for people to make a decision on who represents them again in Parliament and who leads this country from going. I think that there was no rush, really, on the side of the Speaker to immediately pass a reasoning of ruling.
But would you have said same in the case of the Right Honourable Aaron Michael Quay? In the Fomena constituency case, the same argument that you're making, that the people of Fomena also deserved representation. And as a result of that decision, that human right was also violated. Would that find reason in your argument?
You know, Alfred, let me quote a few more cases. You see, because
no, I just asked a specific
no, of course,
question.
I mean, absolutely. You know, when they were making a comparison of the ruling of the respected Right Honourable Michael Quay together with in terms of precedents, okay, because it was an issue of precedents that because an issue of precedents had happened in 2020, it bears foundation for same precedents to be applied in 2024. I disagree and want to disassociate myself from any thinking that goes with the precedents that because Right Honourable Speaker Michael Quay had made a precedence of that nature, it should be applied in the 2024 application. But the Republic versus the Fast Track High Court...
Why would you want to do that? Because in law, you cannot, respectfully, in law, you cannot do away with precedents and make an argument. Because you say you don't find convenience in the precedent, so you don't want to make reference to it. But actually, this decision was not taken in a vacuum.
Alfred, my statements are very clear that there was no need to give a precedence of Right Honourable Michael Quay's ruling vis-a-vis Speaker Bagbane's ruling of 2024.
Why is that?
Because the situations are very different.
How different?
Very, very different. I think that the situations are very different.
How different?
There was no application that was made by the political party that represents these people, that these people are no more members of Parliament. Rightly so, these people are seeking to be independent members in the 9th Parliament should they win the election.
But what law actually demands that a political party should write to the Speaker before Article 97(1)(g) can kick in?
You know, Alfred, it's purely based on who wants to write that. Our political party has not taken a position to write any letter to Parliament to state that these 3 persons that are seeking to stand independent are no more members of our political party. Because there's really no reasoning whatsoever to even convince us that these persons that are standing for independence would be voted into office in the 9th Parliament, because they are seeking their independence in the future Parliament, not the Parliament of today.
But that's beside the point. But if hold on, Prof, I'll come to you. But you see, if 97(1), and have you read the 97(1)(g)?
I have.
And I'll read it to you, that a member of Parliament shall vacate his seat in Parliament if he leaves the party of which he was a member at the time of his election to Parliament to join another party or seeks to remain in Parliament as an independent member. The law does not in any way say that your party must necessarily write to the Speaker.
Seeks to remain in Parliament as an independent member. Have these persons stated that they seek to remain in Parliament as independent members? The question is no. That's true. They have not stated that they seek to remain in Parliament as independent members. You know that. These persons have not decided that they will not do business with the New Patriotic Party or not do business with the government of the day. They have not sought that they want to. It's not in my right place to say that.
No, but I mean,
you understand?
Professor Makokwe was wrong.
That's not what I've said.
But that's what.
No, do you understand what I'm saying?
Then your reasoning, your thoughts aren't flowing properly.
No, then you're not understanding me.
Dr. Palgrave, you are making an argument based on the references you have made.
Article 97, 1G. Let me state it. It says if he leaves the party of which he was a member at the time of his election to parliament to join another party. Has that happened? No. Or seeks to remain in parliament as an independent member. Has that happened? No. So very clearly. And it says that if he was elected a member of parliament as an independent candidate or joins another political party. So for me, you see.
So which law did Professor Makokwe reference in declaring the Fomena seat vacant?
Alfred.
Which law did Professor Makokwe reference in declaring the Fomena seat vacant?
I do not recall that.
It's Article 97, 1G and H.
Which is why we have had to go to the Supreme Court for an interpretation. Clearly. Because you see, if you look at Parliament, Parliament is not the supremacy of the 1992 Constitution. Yes, the Supreme Court brings interpretation.
Which organ of government is...
The Supreme Court brings interpretation of every single thing that is stated in the 1992 Constitution. And I have case in reference to that, if you may. The Republic versus the Fast Track High Court, ex parte Commission on Human Rights and Administrative Justice, interested party, Honorable Richard Anani in 2007 said that we need to remind ourselves that there is no parliamentary supremacy under our Constitution. Rather, it is the Constitution that is supreme. As the interpreter of that Constitution, this court's view of the meaning of the constitutional provision cannot be preempted by that of any other agency of state. In short, a provision in the Constitution means what the Supreme Court says it means, and not when Parliament has declared what it means. And I think that, there are case in references that are there for us to be able to review this. I mean, if you even want some earlier cases like 2022, 2 years ago, you would have the Justice Abdullahi versus the Attorney General that says that no arm of government or agency of state, including Parliament, is a law unto itself. Because without the exception, everyone and everything in Ghana is subject to the Constitution. As a result, an allegation that Parliament has acted or it's acting in a manner that is inconsistent with, in contravention of, and or ultra virus to the 1992 Constitution will render Parliament the actions, orders, rules, and procedures in issue amendable in the jurisdiction of this court. As such, any provision in the orders, rules, procedures, practices of Parliament that contradict, are inconsistent with, or purports to confer on Parliament powers not vested by the Constitution will sin against Articles 1, 2 of the 1992 Constitution. So really, neither Parliament as an institution, nor its members or officers, orders, practices, conventions, or procedures can be said to be independent of or exempt from the limitations imposed by the Constitution. I think that these are very clear. I didn't find any ambiguity whatsoever. And I felt that the minority were on a wild goose chase to want to cross carpet to become the majority in just one day. How does that happen? In a democracy that we live in. This is the democracy. And I think that everyone who wants to make an issue on this statement must really make it based in mind that this is a democracy. And that democracy must not be flouted by anyone, by the interpretation of the 1992 Constitution.
And also guided by the rule of law, isn't it?
Absolutely.
But you see, Dr. Palgrave Boachidankwa, so I think that one of the, and you are a friend of this platform at least, so you know that we uphold some level of sincerity and principle in our comments and association. There are members of your party, senior members for that matter, Katie Hammond and Member of Parliament for, in fact, I spoke to OPK, all of them who have in the Mpaiso constituency MP, who have all indicated in principle that what Speaker Makokwe did was unlawful and was wrong. And they find solace in making that argument now because it goes against the party. And that's why I was asking you that specific question. If you argue that you actually find nothing wrong with what happened, are you saying that what Speaker Michael Quay did in declaring the Formula seat vacant is right or wrong?
Alfred, I want to focus on the issues that are happening today. Clearly, I want to focus on the issues that are happening today and bring interpretations to the issues that are happening today.
I see. Anyway, let me welcome also, because Mama Yarga has had to leave us. You realize we have two NPP persons, that's Honorable Vincent Asifua, and then also Dr. Pagre Dankwa. Al-Hassan Suhini is the Member of Parliament for the Tamale North constituency. Al-Hassan Suhini, good morning, welcome.
Morning, Alfred. Thank you very much for the opportunity to join you. Alfred, I know that my focus or my purpose for being here more has to do with your next topic, but I cannot, thank you for the opportunity. I think that, you see, I have been listening to the submissions made earlier, and I'm not a lawyer. But I've been amazed at the illogicality of some of the arguments that are put forward.
Okay.
You see,
I'm going to come to you,
yes.
Right? And so you make the comment because I need to hear Professor Jampoza. He hasn't spoken on this matter as yet.
Okay.
Yes.
Okay.
Yes.
Okay. But if Prof will allow me to make the point.
I want to have a total governance.
Absolutely.
Yes, because it's coming from the governance perspective. So I needed to make it that right clear.
Yes. You know, Alfred, I think that Mama Yarga couldn't have put it any better. I believe that the three arms of government all draw their powers from the Constitution. And fortunately, we all have our terrain or our places of work. And at the right time, and on Tuesday, the Parliament of Ghana will also exercise its rights as enshrined in the Constitution. But you see, did we have to get here? Did we have to get here? Look, we've been talking about democratic tyranny, especially since Nana Akufo-Addo's government assumed power. And I think what the Supreme Court is doing signals the completion of that democratic tyranny that this government has introduced in this regime. We have seen the abuses that the executive have been engaged in throughout the tenure of President Akufo-Addo. We have seen it countless number of times. In fact, I was listening to like people make reference to the Demoleville case and others, which has even been pronounced by the Supreme Court as abuse of the executive. Several abuses by the executive, as if to say that Nana Akufo-Addo put a gun to the heads of Ghanaians to become president. I think he's worse than even some of the, military dictators we have had in the past. And when I listen to him, when I recall some of his criticisms of President Rawlings, I am tempted to think that he was simply envious of the man, President Rawlings, because you expected better from him. No, Alfred, you look at a situation where the judiciary today have established a certain pattern. There are a number of cases that minority members of parliament have filed before the judiciary, and they are stuck in the courts. A number of them. Me sitting here, I have a case involving the ratification of mining leases. Still stuck in the courts, filed as far back as 2018. Still stuck. Not being moved. You have the e-levy case that the former minority leader and Samuel Okudzeto-Ablakwa and others took to court. It's still stuck there. You have the LGBTQ case, the injunction, not the substantive issue, still stuck there. No urgency whatsoever is demonstrated on those matters. But every single case that the executive have showed interest in relation to the work of Parliament, that has gone before the judiciary has seen expedited action. And in most cases, action favorable to the government. Alfred, and people say we should not think that the judiciary is beginning to seem and act and look like an extension of the executive. And that when you do that, you are endangering our democracy. But their actions that makes it clear that they are beginning to look like an extension of the executive does not endanger our democracy. I mean, are we being rational? That is why the lawyers will tell you that justice is not enough for justice to just be done, and that it must be seen to be done. And so when it walks like a duck and quacks like a duck, you cannot convince a layman that is a miniature. It obviously is a duck. And let me tell you something. The question that Atefa and others haven't been answering is, what were they seeking to to serve on the speaker? What were they seeking to serve on the speaker? Before,
so ask that question.
Yes, what were they seeking to serve on the speaker?
The injunction.
Injunction not to do what?
Which was rendered moot by the speaker's,
Not to do what? I mean, clearly, an action had to be taken, and we know about the separation of powers. Okay. If you have an issue with an action that is taken by the executive, you cannot injunct, for example, you cannot injunct the executive from doing business. And let me tell you the absurdity. Me, I'm not a lawyer. But you see, I was just looking at the Constitution. I see that you want to wrap me up. I was just looking at the Constitution. Article 78(2). Article 78(2) says that the president shall appoint such number of ministers of state as may be necessary for the efficient running of the state. This is an action that is reserved for the executive president. But you see, the word efficient running of the state, or the phrase efficient running of the state, hasn't been defined. And so if I sit in my room and I define it to mean that the president must appoint only 15 ministers, and I go to the Supreme Court to serve an injunction on the president until they interpret this, will the Supreme Court grant me that injunction? Because granting that injunction until they interpret this will mean that the president will not be able to form his government. That is the absurdity that we seem to be introducing with this latest action by the Supreme Court. So because the president has the right to appoint ministers, and I also have a definition of what efficient running of the state means, and I think 15 ministers can run the state, I can go and seek interpretation from the Supreme Court to interpret it to mean that efficient running of the state can be done by 15 ministers. That is my request of the Supreme Court. And based on that, I want them to injunct the president until they do the interpretation. Will they grant me that? Of course they will not, because it's absurd, it's illogical. And that is what they seek. They seek to do with this process that they began, as far back as Friday or Thursday, when it was said that the speaker was going to, pronounce on the fate of these 4 members of parliament. They ran to court to serve an injunction on the speaker so that he will not be able to carry out what is expected of him under Article 97G. I mean, and then you have lawyers who, based on political expediency, cannot see the danger in rationalizing this conduct of the judiciary. And I think that, look, I have heard some people refer to the Chief Justice as the shadow or the deputy woman organizer of the New Patriotic Party. I mean, she must be careful that name doesn't stick. She must be careful that name doesn't stick. I mean, I don't think that if we want to run, you see, these are the things we avoid. These are the things we avoid and endanger our democracy. People must be told in their faces that they are risking our democracy by their recklessness. They are risking it by their recklessness, and let them not hold anybody accountable when this democracy is put in danger.
this democracy.
We all draw our powers from the Constitution. And we all have been educated to read and write and understand. And we know our responsibilities as they are enshrined in the Constitution. And we are all enjoined at every step of the way to defend the 1992 Constitution. And no group of people will be allowed to bastardize it.
Dr. Pachidankwa made reference to, and this is why I bring in Professor Ramfo Jampo. There's a reference which you are not alone in this. I think about a number of lawyers, and then also some persons who identify with the law have made reference to the futuristic implications of the decision. Al-Hassan Sweeney.
You cannot say, you shouldn't be. You see, there's a local proverb in Dagbani that you don't cut the branch that you sit on. And it seems like we are losing sight of the fact that we are all sitting on this branch called Ghana. Yes. We cannot be using the axe on the branch that we are sitting on and think that we will still suspend.
Nobody is using.
Let the judiciary be careful.
Of course, the judiciary.
That they do not endanger this democracy.
To politicize the judiciary this morning is wrong.
It's wrong. By their actions, they are politicizing themselves. By their actions, they are politicizing the judiciary.
What you are doing,
I have told you about the cases that are stuck with the judiciary, filed by the minority NDC MPs. How come that every case that has gone before them from the executive gets expedited treatment?
Well, how? The judiciary is an independent.
And you think that people should just lamely agree with it as a rule of law. The rule of law must not only be done, the justice must not only be done, it must be seen to be done.
Thank you.
I didn't call her so. I said people are saying it on the street. People are saying it on the street and she should not let it stick.
Your microphones are off. And now let me say this. Al-Hassan Sweeney, I am not going to come back to you on this. Yes, I'm not. Because you finished making your point and you were about rounding up.
Yes, I was about.
I would want you to double down on that reference of the Chief Justice. I think
that's not
out of respect.
Especially
and
for the
Dr. Pachidankwa, I haven't called you into this. I haven't called you into this conversation. I am speaking to Al-Hassan Suhini.
Family and friends.
Alfred, to be very sincere with you, I am one of the people who have defended the judiciary and have always sought to encourage many people to show it respect. Because you see, it is the last institution when our politics fail us that we will all rely on to bring us back on the track of democracy. And I am obviously also becoming worried that their actions don't seem to engender the kind of confidence they will need to whip us, the political players, in line when our democracy is endangered. And I did not, and I have never, and I will never refer to the Chief Justice as the woman organizer of the New Patriotic Party. But what I have said, I did not, and I will never do that.
Okay.
But what I have said is that references have been made to her in that manner, and I hope she will be mindful.
So that is what I wanted you to make clear, and make also that particular indication of what you meant, because I would not count.
I have not, and I will never refer to her as the woman organizer.
But
references have been made to her in that manner. References have been made to her in that manner, and she has to be conscious of it.
References do not. Al-Hassan Sweeney, we end here. Do not.
That's fine.
Okay. Now, there's something I want to put on the screen right now. With respect to, and Professor Jampo, I'll bring you here, this particular instance of the futuristic implication of the decision as Dr. Pachidankwa made reference to. And we'll put it on the screen right now. And what the Speaker said in his ruling. He said, if Article 97(1) G and H were to apply, only to future parliaments. They will be rendered superfluous. By the time the next parliament is constituted, any member of parliament who has defected or switched political allegiance during the current parliament will no longer be in violation of this provision. They will start the next session aligned with their new party or as an independent. Thus, there will be no defection and the violation will be wiped clean. That is the Speaker's ruling on this argument of the fact that these persons have expressed intentions to contest future elections. So why is a decision being taken now? For example.
No, you see, I think in the course of the week, I sent you some write-ups.
Yes.
About my positioning on this. I have always not shied away from swimming against the tide. I believe that Professor Michael Quay was wrong in his ruling. Speaker Bagwin was also wrong in this particular ruling. And I have espoused my reasoning, for that. But I thought that we're going to look at the other matters that have risen as a result of such ruling. So, okay, if you would permit me, I'll go back to explaining why I think that both of them were wrong in their rulings that they gave. Then I'll also talk about the Supreme Court's response. Now, let's note this. See, there is always a historical antecedent to laws that are made. For instance, if today you are told that a president can hold office for only 2 terms of, 2 terms, you can do just 4 years and then you do another 4 years. Afterwards, you go away. If you want to appreciate why we have such a law, you must understand our history. In times of history or in our historical past, when independence fighters like Kwame Nkrumah, Leopold Sedar Senghor, Sekou Touré, and all of them had fought for independence and had attained independence, they said that, look, after all, our traditional political authorities, when they are appointed as chiefs or when they are selected as chiefs, they rule till they die. So if we have been able to attain independence for ourselves, we must also rule till we die. So they converted their part, they formed one-party states and wanted to be presidents for life. The framers of the 1992 Constitution didn't want us to go there. That's why they said you can do a maximum of just 8 years. So that's a historical narration to that. Now let's come back to this law that has been a source of this confusion.
So on the basis of principle, it cannot be the case that you would agree with what's happening today. In fact, you disagree with what's happening today and agree with what happened in the case of Professor Michael Quay.
No. I'm saying that both Okoye and Bagbin were wrong, and I want to explain why.
Yes.
Now, so the law that they quoted.
How about Wayoseni?
No, I'll come to Wayoseni's own. Wayoseni's own was the proper application of the law, and I'll come to that, please. So, in 1958, Kwame Nkrumah passed a law called the Preventive Detention Act. Now, that Preventive Detention Act mandated him, Nkrumah, to throw suspected political enemies to jail for 5 years. You go in for 5 years, and before you come, and your case will be heard. Sometimes you can go in for 5 years, and then you come, your case is being heard, and say you are not even guilty. But you may have served even for jail terms for 5 years. So through the application of the notorious Preventive Detention Act, several political enemies or political opponents in the parliament were thrown to jail. R.R. Aponsa was thrown into jail. Victor Owusu was thrown into jail. K. Busia had to flee. Now, there were some politicians or MPs from the Northern People's Party. You can talk about Dr. Bawumia's father, our current vice president and flag bearer of the NPP, his father. You can talk about Yakubu Tali. You can talk about J.A. Brimer. Now, these and other members of Parliament, out of fear of the intimidation tactics of Kwame Nkrumah, voluntarily had to go to Kwame Nkrumah and to plead that they want to cross carpet from their party to join the CPP. In fact, some of them, their constituents, went to beg them that for the sake of your own peace, cross carpet and join the CPP so that you can have your peace of mind. Now, around 1960, the number of the opposition in Parliament had reduced from 32 to 16. And the number of the CPP members of Parliament, after the various cross-carpeting, had increased to 88. Now, it was because they had this kind of majority. That was why they used the numbers to bring about the first Republican Constitution that gave all powers to Kwame Nkrumah. Now, when Nkrumah was overthrown, so I'm talking about a historical antecedent that brought into being these rules. When Nkrumah was overthrown, the framers of the subsequent constitution said that no, we cannot allow cross-carpetings like that to be going on so that we'll be weakening the opposition. So they introduced legislations against cross-carpeting in the 1969 Constitution, in the 1979 Constitution, and in the 1992 Constitution. And the idea then was that if you belong to Party A, you cannot move from Party A to Party B when Parliament is in session. You see, they were trying to guard against what Nkrumah did by forcing the J.A. Brimers, the Baumia's fathers, to move from the Northern People's Party to join their party whilst Parliament was in session. That was what the framers of this law sought to prevent. And so, if you now want to interpret it to mean that if you are a member of Parliament, you cannot, the mere idea of declaring your intention to contest on another party's ticket would mean you should go away from Parliament. I mean, it means you are not being fair to the spirit or the historical antecedent that led to the bringing into existence of this law. See, around the time that these four people were supposed to have declared intentions to contest on different parties' tickets, the number of parliamentarians, in Parliament, according to both sides or according to the divisions, was the same. It was, after they had declared their intention, it was still 137, 1 independent. Nothing had been altered. 137, 137, and 1 independent. The fact that somebody declared that tomorrow I will contest on MPP's ticket never altered MPP's number on the floor of Parliament. So the law has to do with current happenings, current things that are happening in Parliament. And my teacher, Professor Michael Kwe, he knows this. He taught me introduction to Ghanaian politics. Okay, so he knows this. So I was worried that he gave that kind of ruling in the Formina case. And now Speaker Bagwin also did the same. And that's why I'm arguing that both were wrong. But what is annoying is that when it was wrong yesterday, some people liked it. Today it is wrong and they are crying. And you are talking about the fact that the case of Formina is not the same as the case that we have now. In the Formina incident, the man did not on his own say that he didn't want to be, he was actually dismissed by the party. he was actually dismissed by the party. And so it was not something that he said on his own that, look, I'm no longer NDC or MPP, I'm going to go to another party. He had only indicated an intention to do something in the future. Now, you're talking about the Wayo Senis case. It's an excellent example of when the law was properly, implemented. In the Wayo Senis case, he was a member of parliament representing NDC. And whilst parliament was still in session, during that same term, he said that even though I am an NDC member of parliament, I no longer want to belong to NDC. I want to move to MPP in that same parliament. And so he told the speaker alerted the EC, and they said, well, you've made your seat vacant. And that's how come his case was an excellent example of the application of this particular law. But the speaker's rulings, so far, in my view, looking at what really led to the bringing into being of these laws, of this law, the speaker's ruling, Michael Quay's ruling, Bagwin's ruling, in my view, were all wrong. And they were all, with Michael Quay's ruling, we heard what President Akufo-Addo said. He openly was saying that, went about saying, I cannot work with this man. I cannot work with this man. This man was going for him as an independent candidate. I'll not go with him. I'll not work with him. And in my view, that constituted enough pressure on Michael Quay to do what he did. And in Abang Bagwin's case, to be fair, I'm sure he was also not going to be swimming against the tide. The NDC would have also taken him on, that if they did this the last time, you to do it. So they both were wrong. But in my view, Parliament, being a master of its own processes, must find its own ways to address some of these challenges. We cannot upset the balance of power that exists between the arms of government in a manner that makes Parliament subservient to the judicial arm of government and to the executive. The judicial arm of government absolutely has no powers to gag the functioning of Parliament. Parliament, in my view, and this is a simple, common, elementary O-level government. Those of us who studied O-level and A-level government. Simple, elementary, basic O-level government.
Yes, sir.
Parliament is the only truly representative organ of government among the three arms of government. Why do I say so? How many people voted for Nana Akufo-Addo as president? He needed only 50% of the vote plus one.
Yes, sir.
Elsewhere, to make judges accountable to the people, judges are directly elected by the people elsewhere. So that you cannot be doing the bidding of any appointee, any high authority. So judges elsewhere are directly elected by the people. But when if you come to in our part of the world, judges are not elected; they are appointed. It is only within the floor of Parliament that all Ghanaians have representation. So, in an attempt to locate where sovereignty resides, it is common O-level government to place it at the doorstep of Parliament. Because that is where all Ghanaians are.
Duly represented.
That is where all Ghanaians are duly represented. Now, there is a concept of judicial review that grants judges the powers to take a second look at the laws made by Parliament and to declare them whether they are constitutional or unconstitutional. It is there, judicial review. But if people can run to the Supreme Court and get them to halt the functioning of Parliament within the speed, in a speed of light, then there should be no Parliament at all. then Parliament is useless. Because tomorrow we don't know who will be aggrieved. Parliament takes a decision and then he quickly goes to the Supreme Court and then he's able to get them. And the brazen manner with which Afenyo Markin was going about, I have taken it upon myself to, who are you?
He's the leader of the MPP.
And so what?
Majority leader.
And so what? So, like others have said, we have so many cases piled up at the Supreme Court. So many cases piled up at the Supreme Court. And recently, so LGBT, anti-LGBT people, the pastors, the imams, the bishops, and all those
MPs.
The MPs, they all went to the Supreme Court to plead, do something about this.
Yes.
They said they don't have time to do it. But one person is able to get you to sit in a day to take such a decision that, in my view, frustrates the functioning of Parliament. It is an unnecessary attempt to bring the legislative arm of government and the judiciary. But this cannot happen in any serious democracy. It must not be allowed to happen in any serious democracy. And you see, if you have Parliament led or presided over by strong-willed personalities like Alban Bagbin, then you will be sure that such personalities would fight back to assert the independence of Parliament. You know, they can also make laws to circumscribe the way and manner the judiciary also operates. It is within their right.
True.
Okay, so what has happened, in my view, has set the stage for a showdown, another political showdown. Now there's going to be a flexing of muscles between the legislature and the judiciary. And who is likely to suffer? So I'm asking myself, so if Speaker Bagbin comes to say, you said it, but we're not going to respect it, what would the courts do to him? Okay, so I think that the relationship must be guided by a certain mutual respect. Okay, of people must know their turf, and in terms of the balance of power, these are three organs of government that are supposed to wield the same power. But I'm saying that given the composition, how these organs of government are constituted, it is only within Parliament that all Ghanaians are represented. And so you cannot have the Supreme Court come in to frustrate the functioning of Parliament. And I'm worried because they were trying to ensure that government business wouldn't be stalled. And that's why they said they went to Supreme Court. But I can anticipate and predict that Speaker Bagbin would also want to put his foot down. He would also want to put his foot down to check what is going on. And the point must be made. Judicial review is not coterminous with judicial interference. They are two different things. Judicial review is not the same as judicial interference. Judges, the Supreme Court, the courts, the judiciary have the right to do what they are legally mandated to do. Parliament must also function. Okay? And so I'm hearing that people, the judges can also be cited for doing things that are contemptuous of the legislature, and it's also provided for in the Constitution. You are frustrating the work of Parliament, and so they can also cite you for contempt. So what happens if they also decide to do that? So I am thinking that, you see, the leadership of Parliament should be guided by a certain emotional intelligence and maturity. The leadership of Parliament should be guided by a certain emotional intelligence and maturity. And I'm thinking that if it had been someone like Osenche Mensah, he would have known how to go about things such that we would have resolved this matter without plaguing ourselves with this anticipated constitutional crisis. I'm telling you, Tuesday, we are set for a showdown between the legislative arm of government and the judiciary. Because the man is also going to tell you that I also have my turf. Parliament's independence and autonomy must also be protected. We cannot allow a situation where Parliament cannot work because when they are deciding, they are not sure who would take the matter to the Supreme Court for the Supreme Court to say that what you are doing. I mean, we cannot anticipate, we cannot tolerate that. So, I am saying again, if they are leaders leading Parliament, let them begin to act proactively. Let them show maturity and begin to talk behind the scenes. If they don't do that, then the very things they were trying to avoid by going to the Supreme Court, they are going to see them in their worst form. Because, like I said, Bagbin would put his foot down. We know what he's capable of doing. I mean, the history of this parliament, given the kinds of things that he's done, it points to you clearly that he may not countenance some of these things.
And that presents a very worrying and chaotic situation.
Why is a chaotic situation? Yeah, because then there's going to be chaos, there's going to be lawlessness, there's going to be all manner of...
Because you cannot throw the speaker into jail. I mean, if he decides that...
Yeah, but the speaker is also going to tell you that what you did was also contemptuous, because you're also frustrating what he tried to do. So I think that we should have had a certain leadership that was going to be guided by some maturity. Okay. The brazen manner with which some of the things were said publicly, it created an impression that you know what is likely to happen at the Supreme Court. And any time, you see, if we want to build credible institutions, if our independent arbiters are to be trusted, it should be difficult for all of us to predict the outcome of their judgment when we are going there. But if you have a situation where somebody, I'm taking you here, I know what is likely to happen, and then they go and then the same thing happens, and it creates a certain impression that, you see, like has been said here, in the 2013 election petition, the value and the role and the importance of the Supreme Court was very much noticed by all Ghanaians. And the fact that they were the institution, it was an institution that held us together when we were all scared and we didn't know what is likely to happen. It was the Supreme Court that we looked up to. And so I don't belong to those group of citizens who would always want to lambast or run down the Supreme Court. I don't believe in that. But it is important that the Supreme Court itself strive to be in touch with reality. You don't sit in the comfort of the courtroom and then give rulings and judgments that are not, without taking cognizance of what is also out there in the public domain. It is not good. It is not good for our democracy. And so I am saying that if we have leadership in Parliament, let them begin to act now. Because I can anticipate that Speaker Bagbin is going to put his foot down on Tuesday. And so the stage is set for a certain unnecessary showdown that would now stall the course of government. And it is something that if we are truly serious and we truly want to govern and we truly want to prevent and allow government business, to be carried through, then we should begin to be acting, now.
I'm going to come to you because I know you have another point you want to make, but hold it for me. I've been joined on the telephone, thankfully, by Mr. Kweku Ansa Asari. He's a private legal practitioner and then also the former director of the Ghana School of Law. Counsel, good morning. Thank you so much for joining us on Key Points, sir.
Good morning.
I am well, sir. Thank you so much for asking. Now, what we are faced with now, with the majority or the MPP leadership in Parliament going to the Supreme Court with an ex parte motion which has been granted until the determination of the case before it, staying the execution of the Speaker's ruling in declaring some 4 seats vacant in Parliament. What are we faced with now? What's the risk of this particular situation?
Thank you very much. I think, first of all, I need to point out that the Supreme Court did not have jurisdiction if the jurisdiction was not properly invoked. So, whatever the Supreme Court did yesterday constitutes a nullity. Not a void. The applicant, the Honorable Alexander Abraham Martin, brought an application against 2 respondents, like the Speaker and the Attorney General. None of them was properly set with the process. In the case of the Speaker, we are told that the Speaker, an attempt was made to set the Speaker through the legal department. That is wrong. You can either serve the Speaker himself or normally the clerk of Parliament. Never the legal department. That's the first point. The second point is that nothing has been said so far about whether or not the Attorney General, the second respondent, was served. Now, the usual practice is that where an application is brought ex parte and the respondents are not before the court will either have to adjourn or grant the application for a maximum number of 10 days and direct the applicant to bring the respondents by notice. So the applicant, the Honorable Abraham Martin, would have taken steps to serve the Speaker and the Attorney General properly. That was not done. And therefore, the procedural lapses render the Supreme Court's proceedings a nullity. Now, a more fundamental constitutional point arises. Can the Supreme Court impugn a decision of Parliament that was taken in the usual course of parliamentary business? The answer is no. The Supreme Court has no such power. What the Supreme Court did yesterday amounted to provocation of Parliament. They provoked Parliament. Now, Parliament under Article 122 has contempt powers, just as the Superior Court of Judicature also has contempt powers. Now, what the 5 justices did yesterday amounted to contempt of court. And Parliament can hold them before the court. So what the Supreme Court did yesterday was needless. It has created a situation of constitutional lawlessness, which is in nobody's interest. The Speaker can refuse to comply with the directive. And in any case, the directive to Parliament that they should recognize and allow is amorphous. It's meaningless. Directing Parliament to recognize the Supreme Court has no business directing Parliament as to what to do. Under Article 110, Parliament can have the sole authority to regulate its internal procedures. Then the question arises as to whether the Supreme Court can enforce its decisions and orders. They cannot be enforced. The ruling of the Speaker did not contain any executable order. And therefore, what the Supreme Court did yesterday was trying to find a solution in search of a problem. There was no problem before them. And yet, they nakedly usurped the constitutional role of Parliament. To me, That was unfortunate. So my take on the matter, what the Supreme Court ought to have done yesterday, realizing that the Honorable Abenyo Martin as applicant insisted that please, we are here for a maximum 10-day statutory period, no more, no less. In the wisdom of the justices of the Supreme Court, you have none of that. And you give an unlimited, and the young lawyer was led by a former Attorney General, the Honorable Jogasi.
Yes.
And therefore, if the Honorable Jogasi, in his wisdom, tries to situate the issue in context, the Supreme Court justices ought to have listened to them. What they did yesterday was crying beyond the owner of the court. That's what they did yesterday. And therefore, we are heading towards a constitutional showdown when Parliament resumes. And it's needless. At this critical moment, none of the bodies ought to do this sort of thing. And we have a preponderance of authorities in this country indicating that if Parliament does any business, Parliament transacts any business within the confines, its constitutional mandate, the judiciary, the Supreme Court has no business intermediary. That's exactly what they say. As far as I'm concerned, the Supreme Court ruling yesterday amounts to a nullity. It cannot be enforced. It has rather created more problems for the country. Either Parliament calls them for contempt of Parliament, or they should simply refuse to comply with the order, which is a nullity. Because once it is a nullity, any directive or decision or orders emanating therefrom is also consequentially null and void. So whatever happened yesterday is null and void. The directive is null and void. Proceedings null and void. So the status quo, as at the time the application was filed, remained. The four MPs, by constitutional processes, have vacated their seats, and the speaker duly conveyed or communicated the vacancy to Parliament. What business has the Supreme Court to do in such a situation? What the Supreme Court has done is an affront not only to common sense, but also to the powers and dignities of Parliament, as Article 122 clause 6, clause 5 states. So, Article 122 clauses 5 and 6 ground validity to an impending constitutional showdown by way of contempt of court, because the Supreme Court may also wish to enforce a void order. If it is void, it is as if it was never made. That's my position on this issue.
Very well articulated. And you say that with all of this and the happenings at the Supreme Court yesterday, it amounts to constitutional lawlessness, despite the justices adducing some reasons to their ruling that the applicant edged, and they actually appreciated that the said ruling by the Speaker will also likely lead to alleged thwarting of government business in Parliament and plunge the due management of the affairs of the country into possible disruptions. Further, the subject matter of the suit raises real questions of constitutional interpretation and application of the most fundamental and democratic rights of Ghanaians, being the right to be represented and heard in Parliament through their elected representatives. So if this impugned order and ruling is allowed to stand, it will render the grave issues raised in the substantive action negatory. That's their argument, the reason why they came to this conclusion.
Yes, so if whatever Supreme Court did yesterday is technology, it doesn't matter, the rest of the defender, of the division. It's technology. It's null and void. They had no business doing what they did. And procedural lapses, you bring an application against to respondents. The only way the Supreme Court can look at it or entertain it is when its jurisdiction has been properly invoked. And I'm submitting that the jurisdiction of the Supreme Court was not proper. So there's no point even discussing, the ruling in detail. It's a nullity. Before any court, so for that matter, the Supreme Court, can hear a case, it must ensure that the principles of effectiveness and submission, which ground a court's jurisdiction, have been fulfilled. No court, can entertain an action when the parties are not, physically present in front, of the court. No court. Now, if you do that, the proceedings become a nullity because the power under which you could have done it, was not vested or conferred upon you. So, presumably, realizing, the seriousness, of the situation, but the Supreme Court decided to go into the merits. I'm not going to consider, whether going to the merits, was right or wrong. That because fundamentally, they have no jurisdiction. The speaker had not been properly set. You don't, under our law, you don't presume knowability of the court process. You don't. That you presume, as the lawyer said, that the speaker was aware. That's, presumption, that's more harm to the development of our law than good. Secondly, the Attorney General, who is constitutionally mandated to defend all such suits under Article 88, was not there. So the speaker is one arm of government, the Attorney General another arm. So both arms were not there. And the authorities we have show that you have no arms of government. Look after its own domain. So the Supreme Court interpretation. Now, one of the reasons the Supreme Court assigned was that the application raises a serious fundamental issue of interpretation. Who said that? What is there to interpret in Article 97, 1, G and H? There's nothing there to interpret. There are no rival constitutional issues arising therefrom. So it's a straightforward Parliament doing its business in accordance, with the tenet, in accordance with the letter and spirit of, the Constitution. So you go to Article 93, Parliament has its power. You go to Article 97, they know what to do. You go to Article 110, they regulate their own procedure. You go to Article 122, if they regulate their procedure and transact the business in accordance with the laid down procedure, the Supreme Court has no business entering, parliamentary house to scrutinize what Parliament did. That is the law. And therefore, what the Supreme Court has done, rather, is to beg a question, create a situation of constitutional lawlessness, provoke Parliament into a banter that is needless. So this so-called, I will show you where Akosombo power lies. And for me, I'm not surprised because apart from like the Chief Justice, Maria Mousu, the rest are novices, inexperienced. This type of constitutional issue ought to have been, handled properly. Once it has confronted the Supreme Court, the Chief Justice, had to empanel the most senior justices of the Supreme Court to faith and reassure the nation that where we have reached in a democratic mind, we need the wisdom of very senior and able justices of the Supreme Court, not judges who are now learning because they were appointed only 3 months ago. I mean, the issues are too large and looming for them. Next time, I urge the Chief Justice to invite all the justices of the Supreme Court. Let them sit down and agree who are competent to handle such fundamental issues of national importance. The whole world is watching Ghana. The whole world is watching us. We've done it before. We are doing it. We'll do it again. So let us do it properly. Please, Lady Chief Justice, listen to wise counsel and let us stop creating unnecessary tension in this country. For me, my message to both Parliament, the judiciary, and the executive is that there is time to Jojo. There is time for everything. So says the scripture. There is time for everything. This is the time. If ever there was any time for the three arms of government to Jojo, this is the time. The Supreme Court would have invited the Speaker and the Attorney General to chambers to sit down with the five justices and see how best they can avoid the situation of constitutional lawlessness. They did not feel they had the opportunity, they threw it away. And this is raising all of again questions of the way and manner we are managing our developing constitutionalism. Thank you very much.
Mr. Kweku Ansah-Asare, I thank you so much for also this intervention and coming through. And I know you're still watching, so we'll definitely will come back to you as and when. But I appreciate you coming in. Thank you so much. Thank you. That's Mr. Kweku Ansah-Asare. He's a private legal practitioner, the former director of the Ghana School of Law, and also making that intervention in there. And I want to put something on the screen. I'll bring in Martin Kwebu. When Vincent Aftefua, who is the Otafu Member of Parliament, he's also a private legal practitioner, he was making his point about the agreement, conclave between the Speaker and the Chief Justice, as the Speaker referenced when he was delivering his ruling. He had indicated that it is an alleged conclave and asked a specific question of whether he doubted that there was actually a conclave or agreement between the Speaker and the Chief Justice and whether that was actually still in force or had been invalidated. So this is what I was referring to, and this is actually on the letterhead of the Judicial Secretary, Office of the Judicial Secretary. It was a circular which indeed, I think Alexander Fenyomake himself averted his mind to that he was aware that enforcement of Article 117 and 118 of the Constitution, immunity from service of process and arrest. It continues. The Honourable Lady Chief Justice's attention has been drawn by the Right Honourable Speaker of Parliament to potential breaches by actions of some officers or some persons acting on behalf of the Judicial Service of Articles 117 and 118 of the 1992 Constitution. Article 117 and 118 of the 1992 Constitution provides that, quote, civil or criminal processes coming from any court or place out of court or out of Parliament shall not be served on or executed in relation to the Speaker or a member or the clerk to Parliament while he is on his way to, attending at or returning from any proceedings of Parliament. 118, neither the Speaker nor a member of nor the clerk to Parliament shall be compelled while attending Parliament to appear as a witness in any court or place out of Parliament. 2, the certificate of the Speaker that a member or the clerk is attending the proceedings of Parliament is conclusive evidence of attendance at Parliament, unquote. These provisions ensure that the office holders listed above may not be served any process of court or compelled to appear as a witness in court unless Parliament is not in session or the Speaker so certifies that the office holder in question is not on his way to attending or returning from any proceedings of Parliament. Attention has also been drawn to a circular issued on 22nd February 2021 the Honorable Lady Chief Justice is informed that there have been attempts to serve court processes on members of Parliament, the Clerk to Parliament and the Speaker of Parliament, while these office holders are attending to the business of Parliament. In view of foregoing, the Honorable Lady Chief Justice has therefore directed that in serving processes to the above-mentioned officials, the following should be adhered herewith. 1. Right Honorable Speaker of Parliament, how service should be effected. All court processes should be served on the legal department of the Parliamentary Service, and also the Clerk to Parliament. It goes on, and the details as you have. So, this is the conclave or the agreement as was put by the Speaker, and I think that it is there in black and white as I referenced.
Yes.
It is still in force as far as we do know.
Yes.
It hasn't been set aside.
Exactly. So that's why I was making the point that I was telling us if we're that, listen, so the Chief Justice having issued such a directive, if you want to step away from it, naturally you would have to have recourse to Parliament. What does it take? You call Speaker on phone, this, that, and then quickly maybe they will do some writings. Then dissent is mind-boggling. That's the whole idea. I don't get it. Yes, you may have powers, but where you are falling over yourselves, running ahead of yourself to exercise the power, you end up giving people the opportunity to ascribe ill motives. That's the whole point, because the speed was just too much. It's staggering. We had protesters, protesters, the anti-Galamsey protesters, who were slammed into custody. They got bail. More than 48 hours on. The system was too slow. We couldn't get them out. Human beings, where in Pebu number 4, we said personal liberties are priceless. We'll put that beyond or above everything else. They couldn't get out. Yet when it came to this matter, within a few hours, because the thing was filed the same yesterday. The same yesterday, even from the timings, it looks like close to or afternoon, and yet the court was able to sit to adjudicate that. Yet Oliver and Co, Felicity Amoa, all the Felicity Nelson, right, all our gallant heroes were slammed in there after bail. It took days to get them out. So it just, as I've said earlier, reading this directive, the circular, no, we didn't do ourselves any favors. We are eroding the power of the justice system. We are eroding it. And it's, once you erode that power, once you erode that confidence, it will take a very long time to rebuild, because it's been a long time coming. Now it's here with us. It's going to take a long time to build. It's just like the way government just, dismantle the financial system. You remember the DDEP, unbridled borrowing. NDC was warning MPP that, hey, you're over-borrowing. By 2020, you're over-borrowing. Remember, by December 2019, the World Bank and IMF report showed that we had the potential of being debt distressed, etc. These people would not listen. They would not listen. When I go and say man-pam, then they say, don't use that word. So I'm not using the word man-pam, right? But I will say, so you use the word double down. They will double down on their egregious behavior, right? Something is bad, you would sound the alarm, and they say, no, this is even the time for us to do it more. Is that what the Lumber song? Oh, kanukra na miyenu more. Oh, kanukra na miyenu more. Then they thrust us into that deep crater, the financial crisis. And now we are having the same with our justice system. Oh, well, let's see. I hope wise people will rise. Yes, this Tuesday matter. Look, don't be surprised. They will send military there. They will send the military there. I can see. They will send the military there.
At the inception of this parliament,
yes,
that question has still not been answered as to who ordered the military to storm power.
I'm not thinking we'll be able to do that.
And we still don't know.
No role to play.
Does he care about law? By your timidity, you've allowed him. Anywhere else would have been out in the streets, like Sri Lanka. He would have fled even without his sandals. Like the Kwame Nkrumah told the chiefs that they will flee without their sandals. But you are timid. When they say come out and show your anger, you are not willing to. So you allow them. All of this happened because Ghanaians, you are timid. You see wrong, you don't want to say. You are afraid of dying. If you don't die, you think you will get any rights. The rights are not given on the platter. You have to fight. You are not willing to fight.
Okay.
You are not willing to fight. And so if you just like the way some Christians will tell you that, oh, Judas is a traitor, this. I'm like, but you understand your Bible. So if Judas didn't play that role, how would Jesus have died to come and save you? I don't even know what we are doing. But in the meantime, please, before you go, Mr. Mike Aflu has reminded me, Auditor General,
yes,
Johnson Esedu, please, the report on the 52.5 billion that went to GCB, that money from December 2020, you promised that you do an audit on it. 52.5 billion. Is there any wonder that later our financial system crashed? We don't know where the money is going. 52.5 billion. You think that's this in chicken change? And we are still here every day. We remind him, and he thinks he can just look.
So beyond this platform of reminding him, what other avenues can you use to ensure that there's some accountability?
Yes, we can sue. We can sue, but now the thing is, I know we've dragged Ofuriata to court, this SML matter, dragged Cecilia Dapa to court, right? So because of that, usually you want to see one case out before you
put in another.
Yes,
but there will certainly be some.
Let me appeal to other
I'm going to go for
activists to maybe help.
I have to go for a quick break.
The rest of the cases.
Indeed.
Okay, quick break.
I'll be back shortly after this quick break. I have quite a number of your messages. Stay with us. We'll be back shortly.
Over 5 million children have benefited from free SHS. Protect free SHS. Vote Dr. Baumia, #1 on the ballot.
The 8th edition of the prestigious Ghana Energy Awards is here. It is happening live on Friday, 25th October at the Labadi Beach Hotel in Accra. Time 6:30 p.m. Props team. The role of local content in building Ghana's energy sector. Special guest of honor, Osama Makwesi Atta II, Yoman Hene Ogwa Traditional Area. For tickets and sponsorship call 03039400300. Industry partners, media partners, TV3, Graphic News Plus. Validation by Forbes Mazars Ghana. Ghana Energy Awards. 8 years of redefining excellence.
In a place where conviction meets compassion, Heritage Christian University College stands tall, shaping futures and societies. Here, creativity isn't just a concept, it's the fuel for social change. But it's not just about entrepreneurship, it's about nurturing a spirit of service and community. We instill in our students the values of leadership and giving back. Our graduates don't just end degrees, they embody entrepreneurship, philanthropy, ethics, and global competence. Heritage is where innovation thrives amidst a serene environment, offering unparalleled experiences. Come, be part of our journey where creativity and community unite to shape a better tomorrow. Heritage Christian University College, educating compassionate entrepreneurial leaders.
All be lie.
Thank you, boss. See you next week. Yo, where is my passport? Where is my passport? Yo, man, I want to Waba.
What is that?
And then special.
Give me my passport. You made me pay for express for 24 hours, and yet it's not in.
You told me that you are telling me this. What's going on? Hello.
This man here has taken my money. That within 24 hours, he'll do my passport for me.
Oh, see, that's the same applies to me. He told me last night. He's telling me this week. Process. That's what they do. Yeah. Oh, madam. Please relax. I'll get for you in 24 hours.
Hey, Goroma. So you never change? Eh? You get passport for someone within 24 hours, Madam Obwa. See, the normal working hours is 9 to 5. Eh? Not 24 hours, yeah, I'm fat. I'm fat. You guys have made a very big mistake by trusting these people. Now, through digitalization, passport application has been made so easy. Now, you don't need to stress yourself and join any long queue for your passport. All you have to do is to log on to the Ministry of Foreign Affairs website and begin your application. By buying a passport application voucher online. Simple and easy. And very soon, all you need to get your passport will be your Ghana card. What is it true? Yeah, Obisa. It is possible.
Electoral. Vote #1 on the ballot.
show that brings finality to all the critical issues. It is the stage where all the facts are checked, issues thoroughly interrogated, opinions shaped, and debates settled. But over here, we do more than just talk. We resolve problems. We hold those in power accountable. We address all the key happenings in society, from politics to health to education to everything you deem important. And we will center the voice of the ordinary Ghanaian. This is the show that sets the agenda.
Agenda shows Mondays at 9 p.m. on TV3.
TV3, first in news.
Kitchen Wars is brought to you by Kivo Foods, Everpack, Mazim Foods, Miss Cookie Spices, Chana Shito.
He needed to.
Welcome back to Key Point on TV3. We're live on 3FM 92.7, also on TV3 Ghana on Facebook and DSTV channel 279 all across the world on 3news.com and a number of radio stations across the country. Now, stay informed with the latest news updates and exclusive videos by following us on Instagram at 3newsgh. Get breaking stories, code cards, and behind-the-scenes content all in one place. Don't miss out. Follow at 3newsgh now, at 3newsgh. That is the page on the screen right now. I would urge you to make some time and follow at 3News.
The rules of the other court. So we use CI 47, all right?
Thank you.
The ex-party, as I said, usually is for 10 days. So it's being copied. So look, let's even start this way. The rules don't say that you can go for stay of execution ex-party. Okay. But practically, we are learning from the matter of the injunction. In the CI 47, is the injunction you may go for ex-party, right? Right. But copy, in the spirit of the law, the ex-party may not be too much of a problem. Even the court has an inherent jurisdiction. But it's the manner, as we said, justice not only manifestly ought to be seen to be done, right?
Right, indeed. I thank you. This one here says, the Supreme Court's decision yesterday has deepened distrust and hopelessness in the apex court for aggrieved people to seek justice. I've never been agitated in my spirit and the smell. As we're saying now, 18th October 2024, 5-0 decision by the Supreme Court to despise Parliament. It says, we've destroyed nature by our greed with Galamsey. And that is one that we must all be worried about. And now, it says, and now nature is determined to destroy our pervasive minds. I'm sure that's what you'll say. What the Supreme Court says about the representation of South for 4 years, or the non-representation of South. That's what I'm
4 years. And the case went to it, and that's what they said. They said that the thing will take effect the next 4 years. I mean, that's the next election. So SAL had no representation for 4 years. That's the same court. Is this a court that shows that it's interested in
representation for
yes.
I mean, and yet you didn't care about people without representation.
When we say SAL, we are talking about what?
That is I want to take my
in fact, I'm just going to, because it's going to be your last, so that let me just round this. A number of, because I owe the viewers as well some respect on that. Good morning. If Professor Jampo is admitting both speakers were wrong in their ruling, where is the Supreme Court wrong to have corrected the wrong of the speaker? Eric Kwesi Taylor. Thank you. This one here says, all right, this one I cannot read. This one here says, the ex-parte motion against the speaker, that without speaker or his reps in court, the Supreme Court can't treat the Speaker of Parliament or Parliament as an ordinary entity because it will then go against the Constitution, which has already indicated separation of powers. Papa Bishu, thank you very much. This one also here says, Alfred, if you can ask the MPP person in studio, there are two of them, if by his response to your question, is he implying that those three independent candidates are campaigning and contesting on behalf of the MPP? It says, of his obfuscation is rather some of us confusing. Can you ask him to clear this for us? My question is, on what basis are those independent candidates contesting? Are they not contesting the official MPP candidates in their respective constituencies? Yes. You also have another question. Can we ask Professor Jampo if those three are not contesting against both MP and NDC party candidates? If they are, how can they at the same time be part of the parliamentary party?
The numbers have not changed.
No, but it goes beyond that. No, Prof, it's not just about...
The idea was to prevent a situation where you do this cost capital to weaken
in law. When we are interpreting, we are looking at the language. Please,
no, it's not only the language.
We haven't had the opportunity to read the law throughout. Please, let's go briefly to it. Okay. Listen, Article 97, Clause 1, it says, a member of Parliament shall vacate his seat in Parliament. Then you come to, let's start with the easier one, H. If he was elected a member of Parliament as an independent candidate and joins a political party, that's a Siama. A Siama has filed to contest on the ticket of the MPP.
When is he going to do that? In the coming election?
Yes, but right now, he says he has joined.
This has happened before. How did you treat him? When Joe Osewusu, we had the case of Joe Osewusu.
Yes.
How did you treat him?
No, but it depends. If people didn't watch, if people didn't bring it up, then let's go. If we didn't, it's different. Then let's go to G. If he leaves the party of which he was a member at the time of his election to Parliament to join another party, or seeks to remain in Parliament as an independent member, so he has left.
Okay, thank you. I want to jump
because of what Lawyer Febu has just read and what the argument Prof is making. I mean, let's all just calm down and try to answer this question. Assuming in 2025, an NDC member of Parliament announces in February, January 2025, after being sworn in, that I am leaving the NDC, and so I will join the NPP.
Are you saying he did that?
I'm coming. Good. That is the point. He says that he announces that I will join the NDs and the MPP in the next election.
Okay.
Does it mean
in the next
election? Does it mean that the country will permit him to stay in Parliament until he joins the NPP in 2028?
But the law was supposed
is that the intention? The question I'm asking is, do you think? Let me finish the question. Let me finish the question. Let me finish. Go here. Is the intention? Do you think that we will be meeting the intention of the law if we say that, I am going to join NPP in the next election,
10 years,
but for now, I know I'm no longer a member of the NDC, even though I was elected into Parliament on the basis of being an NDC candidate?
Thank you. Question.
Will I be allowed to serve the 4 years? Should I be allowed?
The point is this.
Now, Prof.
I am an MPP member of Parliament.
Yes.
Okay.
Yes.
And then I announce that in the next 10 years, I would want to contest on the ticket of the NDC.
Yes.
How does that invalidate my functioning? How does that
you actually take steps? In this case, you actually take steps to show membership. Because you see, let me explain to you the point I'm making. Let me explain to you the point I'm making with that question. Yes, Alfred. Let me explain to you.
I'll come to you substantively. I'll come to you substantively.
In the narration of the historical antecedent that led to this law, you realize that through the machinations and intimidations of the CPP that led to the cross-carpeting, the numbers of the opposition got reduced.
Yes, but if you look at the current language,
but in the law grows.
The law grows. The law is a living organism.
In the current circumstance,
we don't do statistics.
When somebody says that I intend to contest on another political party's ticket, how does that reduce the 137 plus
The one independent.
It doesn't do anything to the number.
You know what goes into it? The meetings and the negotiations. The meetings and negotiations that go on. So for all intents and purposes, he has left.
Can't we have intentions?
Thank you. Now, thank you.
No.
Let me conclude. Let me conclude. Gentlemen, I will come to you. I'll come to you.
In this
Thank
case,
you.
we have moved from intention to showing you the poll of the notice of poll.
Exactly.
That's small. In which parliament is he going to?
In the ninth parliament.
In the other parliament.
The parliament of the future.
And there
are no indications that the person would even win the election.
But what is he doing now? Once he goes to join, it's negotiations. Do you know the things that go behind? So for all intents and purposes, his mind has left his party and joined the other one. And that's what goes on. And that's what goes on.
Your microphones are off.
But the law grows.
Your microphone is off. Yes, this one, Hadi from Pig Farm says, I'm sorry. When it came to judicial and cases, the people did not deserve representation, but in the ruling of the Speaker declaring parliamentary seats vacant, the Supreme Court thinks the people deserve representation. May Allah save Mother Ghana. Hadi from Pig Farm, you say. John Kofi, thank you. You are drawing our attention to something to do with the channels going off in Takoradi and Naji. Okay, so we're working on that. So that's just for the notice. Those who cannot view us in Takoradi and Naji, it's been worked on. Vincent Asefua, it says, okay, so he's off now, but it says, but about understanding the law and being able to research it is one ability you cannot take away from Martin Pebu. He has contributed to the legal jurisprudence in this country, and we don't give him enough of his flowers. Pebu number 1, 2, 3, and 4 is an authority in legal education in this country. Kudos to him. And I have not minced words on this, even though he's very...
Yeah, it's the Supreme Court. They are shaping the law. They want to take us to the first class.
We'll be back after. I need to go for a quick break.
He doesn't know
Yes, I'll go for a quick break. It's a quick one, so we conclude. Quick one. Stay with us. We'll be back.
I see, Monsieur Lemmy, 200 Ghana could also sister. Buy you in your 5 cities and then 40 Ghana. Hey, take one container your 40 to 50 pesos and not 20 Ghana. And then a dancing or long can do 30 Ghana. Aday, on my bay money away.
Oh, so Casa, Michel Dean. Sha, Doctor me 20 Ghana. Ah, me pay for me 15 Ghana city a day. Omo be na woman ya koya na ate yesan bai
hwe enye duane bo nko an ne kosoro John Dramani Mahama time Smith 1 bag ne ye 24 Ghana cedis me nko to Smith 1 bag a ye se eye 108 cedis ayon ross ye beton sen it is say wo si dan a sen na wo be say John Dramani Mahama ba ma giye a ye be wo
ya nya bibia fa ho akom be kuyen yo
akom ne de enkuyen ye be fa ye ho adwen pa na MPP aban wadi ehwammo ankasa
medie minim wo haw na medie mehwe masetinam na mato ababa
ene sa na tie de a eye akufu ade ne ni ba wo mi a nyame ya dom ne se December 7 dura ye be tuo masese de YouTube
ye be tu ankasa
hwe wasetinam moto abapa e de sakraya papa beba wa brabo mu to abama John Mahama ne NDC.
In uncertain times, it can be hard to imagine yourself completing the CIMA professional qualification. But with our new Digital First Learning and Assessment platform, you can. The CGMA Finance Leadership Programme, or FLP, gives you control over your study progress. The CGMA FLP is a remote-based, self-paced learning platform that lets you qualify from home with online assessments.
Luckiest star 712#.
Luck is everywhere.
8K. Hey, you get an 8K. Get a package on your book, man. Wallah. Hey, wait.
You can put it on his tab. This is my man.
Good luck. Hey, yo, ready. We are star 712. It's much more follow. I'm on dialing the magic numbers. Star 712. Now welcome to the luckiest.
Aha, and now with me at ticket. You can buy for yourself or your loved one.
Ah, mommy, tell mommy who's here.
You're buying for me, right?
Or who else?
Oh.
Let me choose buy tickets for others.
Love you, boo boo.
Maybe straight to option 4. Now, you need to buy tickets worth 50 Ghana to qualify. Yes, you can buy random or preferred tickets. I'm choosing the random ticket. Listen, if you buy the random ticket, the system chooses a random number for you. But if you buy the preferred, you get to input your own preferred 5 digits. 5.
Baby, give me your 5 numbers.
And how much are we buying?
Babe, look at the body and buy you.
With your body,
Hey,
never. Tread cautiously. Now follow the prompts and prepare. Now the luckiest.
The luckiest is regulated by the NLA on the Caritas platform, not for persons below 18 years. TNCs apply.
Over 5 million children have benefited from free SHS. Protect free SHS. Vote Dr. Baumia, #1 on the ballot.
Welcome back to Key Point on TV3. We're live on 3FM 92.7, also on TV3 Ghana on Facebook and on DSTV channel 279. We're all across the world on 3news.com. There are very many ways that you can connect with us. And at this moment, let me tell you that I am clothed today by Kogra Clothing, the best version of you. Locate them on the Spintex Road and 18 Junction, opposite the Allied Oil Filling Station, ground floor, same building with the Ghana Made store. Call Kogra Clothing for this and more on 0244 238 341. 0244 238 341. On WhatsApp 0500 9099. Choose Kogra Clothing, choose right. That's 0244 238 341. And I need to acknowledge the 4,623 of your messages that have come through. I thank you very much for all your thoughts and views expressed on this matter. Thank you. Alhassan Suini, while we round up on this matter, Kizito from Tema East says, no wonder we have to continue to question our democracy so that we can grow it. It is important that we all speak up at this time and speak up through the right channels and defying all the odds. Silence is not an option, you say. Thank you very much. Alhassan Suini.
Yes, you see, Alfred, on Prof's questions, you see, by the Constitution, everyone or every citizen has a right to join a political party. And my stress is on the article a political party. So you are not allowed to join 2 different political parties
at the same time.
At the same time. We are all allowed to join a political party. So you cannot join a political party based on the Constitution and move from being a member. Can I finish, Prof? Please, can I finish? Please, Prof, if you interrupt my chain of thoughts. Thank you. You cannot join a political party based on the Constitution and then move from being a member to entering into a contract with a group of people in a constituency to represent them in Parliament on the ticket of a political party. Remember that your chance to be in Parliament is a contract that you enter into with the people that you want to represent. And the people vote you into Parliament to represent them based on the ideals of the party that you claim to belong to. Now you get to Parliament, and then you decide to serve another party's interest. 1, because you cannot by constitution belong to 2 different political parties, you would have been going against the Constitution. And 2, because you also have a contract with the people who voted you based on your affiliation to a particular political party. If you go and begin to work with another political party or show your intention to collaborate with another political party, you would have been betraying the trust that the people put in you. And that again mass matter. It is not just about numbers. Your argument of numbers is true and important, but it is also about the relationship and the contract. You gave me 3 minutes, Alfred. So it is important that we get this clear, that once you go into Parliament in 2025 and you show by conduct and by deed that you no longer belong to the party that brought you to Parliament, you cannot continue to be in Parliament even if your claim is that your conduct and your intentions will manifest in 2028. Especially in this case where we have shown proof that these people, in the case of the independent candidate, has joined the NPP. Because if you are not a member of the NPP, you cannot file to be its candidate. That is according to their party's constitution. Apart from that, the other members have also filed to be independent candidates, and that is where H kicks in to catch them there. Apart from that, look, when you look at 97, the sub-clauses, there are some automaticity to some of the, provisions under 97H. For example, when Parliament is dissolved, are you going to wait for anybody to write to you that you are no longer a member of Parliament?
No.
If you write to the Speaker to say you are resigning, are you going to wait for Parliament to write to you to accept your resignation before you are no longer a member of Parliament? It is the same thing with G and H, where it says that when you join a political party, either than the one that brought you to Parliament, you are no longer a member of Parliament. You don't need a committee to sit on this. That automaticity kicks in. Again, when you are an independent member and you join a political party like the independent member has done, you don't need a committee to sit on this. And the Supreme Court says that they are basing their actions on fair representation. Look, Mama Yergal said it earlier. The Constitution itself anticipates where people will not be represented. And that is why, under Article 1126, it says that 3 months to an election, if there is a vacancy, there will be no by-election. Within that 3-month period, doesn't mean that it is unfair for the people of that constituency not to be represented. Quite apart from that, you look at Article 1102 of the 1992 Constitution again, and it says that Parliament may act notwithstanding a vacancy in its membership. Parliament may act notwithstanding a vacancy in its membership. So let not the Supreme Court be fooled by some people in government that if they do not do that, Parliament work will suffer. Parliament will work whether those people are there or not. But again, I just want to conclude on the note that it is beginning to be glaringly, the Supreme Court is beginning to be glaringly biased, and that is dangerous for their image and dangerous for our democracy. In the case of Jackie Kwesi, all the cases of Jackie Kwesi, in the case of the e-levy, in the case of election of second deputy speaker, the Supreme Court moved with alacrity to determine the cases in favor of the executive. But in the case of the same e-levy by the minority leadership, in the case of many other cases, the LGBTQ and others, where members of the minority have interest in and have filed before the Supreme Court, we do not see the same speed being exhibited. And that must be checked to protect the image of the judiciary and also to strengthen our democracy.
To you that in the to you, it says, in the spirit of being principled in our politics, I says I've respected Dr. Parkway Batidankwa's consistency in even speaking the truth when it is against his government.
Really?
This morning,
you haven't been listening
it says,
to him
no, this is somebody reading a message. I'm just reading a message. It says this morning he sought to disappoint. This morning he sought to disappoint me. He's not alone if he agrees that Speaker Michael Kwei was wrong, and it will not change his color. It is just about being principled as a human being. Dr. Batidankwa.
Alfred, all I said was that I don't want to give a position on Speaker Michael Kwei's statement. That's all I said. It doesn't mean I agree.
I asked the question.
It doesn't mean I disagree.
I asked a question. So are you saying you're not going to answer the
question?
No,
I mean, Alfred, you see, that's why I said I mean, all I said was I don't want to give a position on Speaker Michael Quay's statement.
No, but I believe in your intellect. That's why I was asking you the question whether you agree that he was wrong.
I would want you to hold on to that. But really to state that, I have a question and then I have an answer as well to the question. In this country, we don't run parliamentary supremacy. Neither does Parliament withhold all the rights. What we run is constitutional supremacy in this country. And so really, for me, what would take place on Tuesday is that the majority in Parliament, led by the majority leader, the Honorable Afenyo Makin, will lead the side of the House to sit at the majority side, whilst the minority, led by Atoforsen, will sit at the minority side. Because we run a constitutional supremacy in this country, not a parliamentary supremacy. And those will be my concluding remarks.
I have to go for a quick break again. I have to go for a quick break. Gentlemen, please. 30 seconds. I'll be back.
Over 5 million children have benefited from free SHS. Protect free SHS. Vote Dr. Baumia, #1 on the ballot.
Lawyer Martin Pebble, no, you have to just a minute on this. It says, do Articles 97G and H need interpretation, or it is a provision when breached, its application is automatic and not subject to any interpretation? 1 minute.
Yeah, I think, look, 97, 1G and H, they are clear enough. They are clear enough. And that's how come even the standing orders of Parliament, right? Okay. It says that the Speaker is just to inform the House on the vacancies. Listen. So it says, I'm reading this 18. 18 says, the Speaker shall inform the House of the occurrence of a vacancy of the seat of a member of Parliament under Clause 1B to E, G and H of Article 97 of the Constitution. Okay. So you see it says that the Speaker should inform. So it means that the lawmakers themselves intended that this would be simple and this would be applied. I mean, I don't see anything that's rocket science about this provision. It's so clear. Right. Look, if he was elected, the H, a member of Parliament as an independent candidate, and joins a political party, are you saying ACMI's documents at the EC on the ticket of the MPP are false? The notice of poll is false? And then you come to Kojo Asante, the others. Are they not going independent? So the Jing has he not left the party? Kojo Asante and Co. The documents at the EC, are they for a joke?
Thank you, Counsel. And Simon, who's a senior parliamentary journalist, in fact, known as Fabaka 2008, says, good morning. Please, the Speaker in his statement indicated that on the EC's notice of polls, these 4 individual names have been captured clearly that they are contesting the elections as independent candidates rather than the party that brought them to Parliament as MPs. So the EC's notice of polls is the evidence, and the Speaker doesn't need to wait for any political party to write to him.
Yeah.
Thank you. Professor Jampo.
If I have a little time. So I just wanted to respond to my brother by saying that a member of Parliament does not represent only his political party in a constituency.
All right.
And so if you are voted on the ticket of the MPP, right, and you become an MPP member of Parliament, you don't serve the interest of only the MPP. That's why it is wrong for us to describe President Akufo-Addo, for instance, as MPP president. He is our president.
Okay.
If he becomes an MP in the area, he is the MP for the area, regardless of the fact that the political party sent him there. And the other bit is for us to appreciate the fact that you are doing the same thing that I didn't want me to do. So you see, in 2008, Joe Osei-Wusu, Ofori Kragu, Seth Ajeba, they got to Parliament as independent candidates.
Right.
Now, in 2012, when they wanted to go again on the ticket of the MPP, their seats were not declared vacant because the speakers there knew the real meaning of this provision, this legal provision that we are talking about. And so my view is that the law has everything to do with the functioning of members of parliament in the now, and not a declaration of their intent. But the last thing that I want to say is to address my people by saying that, my dear UTAG members, you have shown resilience.
Your chapter.
You have shown resilience, and you have demonstrated that you are the true conscience of the nation, despite very flawed and infantile attempts to break our ranks. You have been resolute, you have been resilient, you have stayed true to the fight against irresponsible mining. We are still on strike until the National Executive Committee of UTAG, decides otherwise. So I wish you well. Aluta continua.
Professor Ransford Jampo is the president of the University of Ghana, UTAG, and also a professor of political science. Thank you. Lawyer Martin Kwebu, appreciate you coming. Thank you so much. Thank you. Dr. Pagre Bachidankwa, thank you so much for coming. Alhaj Al-Hassan Suhini, appreciate you. Thank you so much. And also want to appreciate gentlemen, we are done. We're done. Alfredo Kanse, on behalf of the rest of the team, have a great weekend and all the best.